I just checked with the clerk over here, and they don't have.
My dad said you were down at the boys camp the other day,
What's that?
Wayne County Boys Camp. My dad works down there. He said he saw you down there. Chris Lovelace.
I don't think, no.
You weren't at the,
Yes, sir. This is Brad Chapel from Public Defender's Office. I had sent a couple of pieces of paperwork yesterday afternoon. The fax number, I believe, is 606 387 8154. Is that right?
I've got it saved in my fax machine.
What, just a second, let me confirm that for you. 387 8154. That's right. It's Sanders, and he'll have two different cases. One, some of the papers will say Commonwealth, some will say Clinton. I hope it's John will sign it. And also mark that. All right, thank you.
It just take a week. It's all right. I mean, we backed up and slept on the way over there. I got in, because they had a big word about it.
Well, he ain't in court. Yeah. Okay, but there might be more people who are here.
Rotor is going to be on, but they still said they can. That would be important.
All right. Next circuit courthouse session, starts Saturday weeks presiding. Make sure all your cell phones on silent. That again, on the top. Thank you, man. In person. Commonwealth versus James Abson. We have a special prosecutor case here.
Yes, sir.
Judge, that's the rest of the gentleman on schedule.
Twin.
Yeah.
Special prosecutor.
Yeah.
it's a Russell County jail, they're not gonna be on.
That's what I'm thinking. The Russell County Jail won't be on until 10. Okay. Commonwealth, Kentucky versus James absent. 22 CR 0023. Are you James absent? You're here for the purpose of arraignment.
Yeah.
Yeah.
Can you turn it down?
Went to get the file. They've gone to get the file. Thank you so much. Commonwealth versus James, absent 22 CR 0023. Are you James absent?
Yes.
What's your year of birth?
6/21/57.
1952 is your year of birth. What's the last four digits of your social security number?
269.
Okay, yeah, you're here for the purpose of arraignment. You have the right to remain silent. If you have any questions, you just step up to the podium and ask your attorney, okay? The grand jury of Clinton County is returning indictment charging you with failure to use a seatbelt, operating a motor vehicle under the influence, and wanton endangerment in the first degree, 2 counts. You understand those charges? Counselor, do you acknowledge the identity of your client? Proceed indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions. Mr. Stockton, what is your negotiation day for next month?
May 6th, 9 o'clock.
When is? Okay, you'll be here on May 6th for negotiation and May 12th for your next rule day, okay? I'm signing a reciprocal discovery order. Commonwealth would be giving you a package of information to help you prepare for your defense. Thank you. Troy Albertson. Been served.
Yeah, he's the one waiting on the independent contract in case he thinks that I don't know if we ever went or not.
No, that's Tommy. It's Troy.
Oh, it's Troy.
Troy. I might have said.
Yes, he was served.
Do what?
He was served on March 17th.
Okay, issue a bench warrant, no bond. Ivy Branham. Commonwealth versus Ivy Branham, 22 CR 0009. You're here for the purpose of arraignment, represented by counsel. Ms. Branham, what is your year of birth?
1998.
And what's the last four digits of social security number? You have the right to remain silent. I suggest that you exercise that right. If you've got any questions, step away and ask your attorney. The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance in the first degree, methamphetamine, possession of marijuana, possession of drug paraphernalia, and trafficking in controlled substance first degree. You understand that charge? You understand? You need to say something.
I said yes, Your Honor.
Okay, yeah. You got to speak loud enough to key the mic.
Oh, sorry.
That's, I'm signing a reciprocal discovery order. We're giving you information to help you prepare your defense. Be back here 9 o'clock on May the 6th.
And then on May the 12th, 6th is for negotiation, the 12th is to enter a plea or set a trial, do any motions. Both of those are conditions of your bond. You understand that? Okay. David Brown. David Brown. Commonwealth versus David Brown, 22 CR 00016. Are you David Brown?
Yes,
Born in 1972. Last four digits, social security number 3541. Okay, you're represented by the Office of Public Advocacy. You have a right to remain silent. I suggest you use your right. If you have any questions, step away from the podium. Ask your attorney. The grand jury Clinton County's return indictment charging you with theft, unlawful taking, disposition, persistent felony offender, second degree, 2 charges. You understand that? Counselor, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, and a plea of not guilty, reserving all pretrial motions.
Yes, Judge.
Okay, I'm signing a reciprocal discovery order where it says that they'll give you evidence they have to help you prepare for your defense. There's a negotiation day scheduled on May 6th. Your next court appearance is May 12th, and you're required to be here both days. You understand? Okay, thank you very much. Laura Burchett. Come on around, Ms. Burchett. Commonwealth, Kentucky versus Laura Burchett, 22 CR 002. Are you Laura Burchett? What's your year of birth, Ms. Burchett? Last four digits, your social security number. Here for pretrial conference. What do y'all have in this case?
Your Honor, if you just say, this is the case, I feel like if we had one more, I think this has to settle.
What does the Commonwealth have to say?
I'll agree with that.
May the 6th, you'll be here for negotiations on May the 6th, and back here to either enter a plea or set a trial on May the 12th. Edward Daley, it's an active warrant out for Edward Daley. Is there an active warrant?
Sheriff said no, but we don't know for sure.
We'll check. Commonwealth, Kentucky versus Edward Daley, 22 CR 0013. Are you Edward Daley? Yeah, were you born in 1951? What year were you born?
3/16/51.
Okay, 1951, you were born in, right? What are the last four digits of your social security number? Okay, you're here today for the purpose of arraignment. You have the right to remain silent. Pull it up over your nose. If you have any questions, you need to step away from the podium and ask your lawyer, okay, to protect your privacy. You understand that?
Well, it's bond. Right.
10,000 cash or 2 times property.
No addition about.
Yes, 24-hour curfew, no contact with victim or victim's property and all other things.
Has he been processed?
It was served on March 17th.
Okay.
So it is served.
We cannot have the door open like that.
I gotta get somebody to fix the door up.
It locked. It broke on.
It's a beautiful day today in the neighborhood. Somebody has my parking place. I get distracted. Leave the briefcase over there. That door's unlocked here, so people can come and go who they want to, and now the doorknob's locked. I'll just, I would take a vote on a clemency and just let all of you go home, but I don't think we probably. The grand jury of Clinton County has returned an indictment charging you with wanton endangerment in the first degree. 4 counts. And criminal mischief in the first degree. Do you understand those charges? Do you understand those charges? I don't want you to comment. No, I don't want you to comment. No. You understand what you're charged with?
Yeah.
Okay. Okay. I don't want you to say anything because it could be used against you. You got a right not to say anything right now. Now, you're out on a bond, and the bond says that you've got to stay away from the people that accuse you of this. You need to stay away from them. You understand that? Okay. If you don't, I'll revoke your bond. Okay, you be here for negotiations on May the 6th and back for a pretrial on 12th. Ronald Daniels. Mr. Stockton, what do you know about Ronald Daniels?
I may have not been located by because his name is spelled wrong on at least one of the indictments. I don't know which way is the correct spelling. He's Daniel. It's,
I always thought they were Daniels.
then there's Daniel, so.
I always thought it was cool.
it's unsafe. It's unsafe.
Yes. Pretty good. I'm on the bench with them. What happened? What happened? What happened?
Yeah, I'm still showing it, sorry.
Mr. Daniel has not been served, is that correct, Mr. Stockton?
Yeah.
Okay. Virginia Daniel. Commonwealth Kentucky versus Virginia Daniel, 21 CR 00122, 21 CR 0073. You're here today for pre-trial conference. What do you have?
He's in special report, Your Honor, on one case. I want to pass this to see how she does it. Then she's not off to a good start. I'm going to give her one more chance. I'd like to see if she can complete her code or not. If she can't, she's just going through.
I guess you heard that, didn't you? You think he's kidding?
No.
I don't think he is either. And I don't like to send anybody to prison. I don't want to send you, I don't, you know, very few people are improved by prison. Some of them are. But you need to double down if you want to stay free. You understand what I'm saying? Okay, so you want to continue the other case generally, Mr. Stockton? Both of them?
Yeah, I think she's in a range on one case. Let's just continue both. She doesn't do very well already.
Okay. Austin Edwards. Commonwealth versus Austin Edwards, 22 CR 0021. Are you Austin Edwards? Were you born in 1999? Last 4 digits, social security number are 5883. Here today for the purpose of arraignment, you have the right to remain silent. You're represented by Mr. Cross, who's entering appearance. If you have any questions, step away from the podium and ask Mr. Cross, okay? The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance in the first degree and disorderly conduct second degree. Do you understand those charges, Mr. Bailey? Cross, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, interplea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. Your attorney will be given the information to help you prepare for your defense. You'll be back here on May the 6th for negotiation and May the 12th for your next appearance. Continue on the same bond.
Your Honor, there's some additions on the bond. So.
Well, let's just find out now. What are the bond conditions?
It's a $15,000 worth of Perdue, 24-hour church with exceptions being word of church, doctor, subject to random drug and alcohol testing and all other standard conditions.
We have to call them correct.
Whoever did this bond, that's put those conditions on there. Look at that. Stephanie Edwards. Stephanie Edwards. We have negotiation days for you to talk to him. You need to move away while we go through this document. Stephanie Edwards has an active warrant out for her, it says here. She's not present, so I'll just inform you. Joey Garrett.
Your Honor, Mr. Garrett's in Fentress County Jail and there's a holder on it, so it's supposed to be out. The last word I got 100 days in jail down there, so I don't know how long it's like.
Well, we'll issue a bench warrant here on him and then we'll do what?
There's a holder on it.
From here?
It's a warrant on a revocation.
Yeah. Okay,
That's been said.
okay. Sue Gilbert.
That hasn't happened. There's a warrant.
Okay, what kind of warrants out for Miss Gilbert?
Probation violation.
She's not aware of the warrant that was made in the court that.
As long as she's confessed because she's been stoned. She hadn't reported since February of 2021 for the violation for that.
Commonwealth versus Sue Gilbert. Are you Sue Gilbert?
Yes, sir.
What's your year of birth?
81.
Last four digits of your social security number.
5929.
Your Honor, according to revocation paperwork, February 22 is the court date. So also in March. But, she came where the court date and she came.
Mr. Stockton, what do you have?
Well,
Yeah, let me, wait a second. Brad, y'all move over this way. Move over this way, ma'am, and move over this way, ma'am. Okay, and Jesse, I'm having a hard time hearing today. If you move over there, thank you.
I was just reading the current violations, and the first one says February 18th, 2021, but it looks like she had reported on February 18th, 2022. And it looks like she had some failed drug tests.
Ma'am, you'll get your opportunity if you want to step away and talk to your attorney. He can't listen to Mr. Stockton and you too. You want to call your witness, Mr. Stockton?
Yeah, Mr. Martin. He can tell the court what's going on.
You raise your right hand, officer. You swear to tell the truth, the whole truth, nothing but the truth.
I do.
State your full name, with whom you're employed, in what capacity.
Thomas Christopher Martin, I'm assistant supervisor with District 20 Probation.
Evidently, you've had some problems with this case. Mr. Martin.
That's correct.
Tell the judge what's going on.
There was prior violations stemming from 2018 with positive drug tests. In 2019, subject had attended 9 sessions with CBI at Foothills. She was directed at that time to attend 12 sessions. So it's my understanding that she was compliant with that. Update to currently on February 18th, 2022, Ms. Gilbert failed to report as directed. On March 11th, 2022, probation parole conducted a home visit at subject's life reported address. Officers noted that a male claiming to be her father came outside and was complaining that they were jerking her around and she should be off probation. The officers asked if she was there, and he said no. The officers then asked if she was staying there, and he said most of the time. They asked where else she stayed, and he said on 1880. Officer Farrell then said that isn't that Cumberland County? He said yes. A contact notice was made and left directing Ms. Gilbert to report Monday morning at 8 o'clock at the Marcel office. On March 14, 2022, Ms. Gilbert failed to report to the Marcel office. She did call the office and spoke with Carson Payne, her previous officer, before he took another position. Before he had a chance to let Officer Farrell know that she had called, subject either hung up or the call was disconnected and she did not call back. At that point, we checked Justice Exchange to make sure she wasn't incarcerated. She wasn't a patient in local hospitals. And at that point, she was concealing her whereabouts and current location. And we submitted a violation report question.
When was the last time she experienced that contact?
It does not specify that, but it would have been January, since they noted the February report in February.
You were never her correct officer.
That's correct. It was
Mr.
Mr. Payne previously, and then he took another position. On staff and stepped into a seat.
When did you take the case?
Technically, it's not a case. As assistant supervisor, I helped fill any gaps when we had openings in office.
So, she's been on probation for approximately 4 years.
Since April 2018, that's correct.
So, yeah, you did know a few issues and that happened in 2018.
That's correct.
If she would have missed a report date, it would have been noted in there.
Okay, that's, here's the thing about it. What do you want her to do?
I want her to.
No, I'm asking him I know what you want. You want to comply with the law, but what requirements you want me to put on her?
If she'll report to the office as directed and follow our conditions of supervision, we're more than welcome to continue her supervision.
You don't need to say anything. This could go pretty well for you if you I'm just telling you this. Just listen to me. Make your call in, do what they say. You're not on probation for that much longer. You can get off and be free as a bird. So you're going to leave here free as a bird. Now are you going to comply?
Yes.
Well, you're good. Be on your way rejoicing. Okay? Thank you very much.
Do I need to recall the warrant?
Recall the warrant. Pamela Guffey. Versus Pamela Guffey, 21 CR 00119. Are you Pamela Guffey? What's your year of birth, Miss Guffey? And what are the last 4 digits of your social security number? 6176. 6476.
Your Honor, Ms. Guthrie appeared at our federal conference as well as a separate meeting with me.
he mentioned something to me, I don't mind doing one more pre-trial.
Okay, let's have a negotiation day of May the 6th, and your next court date is the 12th. You'll either need to reach an agreement with them or set a jury trial, okay? Nikki Hutcherson. Commonwealth versus Nikki Hutcherson, 21 CR 00124. Are you Nikki Hutcherson? What's your year of birth? Last four digits of social security number. We're here on a pretrial conference. Counselor, what do you have to report?
Your Honor, we have a pretrial version of the agreement.
Okay,
I have the paperwork.
wait just a second. Wait just a second. Keep the paperwork there. Motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol? Is a plea freely and voluntarily given? State your full name. Are you the same person named in the indictment that I just read? Is your judgment impaired today? Is your judgment impaired today?
No.
Okay. You understand the charge against you, and are you satisfied with your attorney's advice? Have you reviewed the evidence which the Commonwealth against you? You feel like you're fully informed about your case? Okay. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea of guilty, I need to know whether you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak, trial by jury, right to be represented by counsel, jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. If you're guilty plea today, you give up those rights. Now, have you had a diversion before? Okay, are you present on probation or parole? Have you previously been convicted of a felony? Okay. I'm going to listen to the Commonwealth's recommendation here, and I don't have to accept the recommendation, but if I give you something more harsh, I'll let you withdraw your plea. Mr. Stockton.
Your Honor, Ms. Hutcherson plead guilty to amended charge of traffic and process of first degree less than 2 pounds. It was sentenced to 5 years, pretrial diversion for 5 years. Served SSC, received credit for time served, pay costs discretion of court, maintain gain on employment.
Okay. Have you reviewed the written motion for diversion with your attorney? Is that your signature on it? Okay, you understand that if you complete the diversion agreement, the case will be dismissed pre-trial verdict. However, if you violate the terms of agreement, you'll be brought before the court. And if I find that you have violated, I'll revoke it. It'll be a pre-sentence investigation report done by probation, parole. You'll be sentenced, you'll be a convicted felon. And at that point, any felonies you have in the future, this could be used against you to enhance the penalty. Do you understand that? Okay, I have the order granting diversion here, and I'm going to sign it.
But that's never the way.
Dual representation. Who else are you representing? Do what? Who? Okay, do you waive that your attorney can represent you, Mr. Poole or Tool? Tool. Okay. Okay. You'll need to go over and meet with the probation parole officer there and give him certain information. Michael Keith. Commonwealth versus Michael Keith, 20 CR 0023. Are you Michael Keith? Born in 1980?
Yes,
Last four digits, your social security number are,
296.
okay. Says motion to set for trial.
I don't think that's correct, Your Honor. I've been putting this case off because I'm having difficulty with co-defendant trying to either get a trial date on it or get a plea agreement. That's Ricky Phillips and evidently Jill Wilson Jones represented him. Until recently, she's going to try to withdraw because she's not doing any more conflict cases. And I need to dispose of the Phillips case before dispose of Mr. Keith's case. If we continue this a few months, maybe I can get Mr. Phillips' case.
Call it back up for July 14th. Is that okay?
That's fine with me.
And I'll depend upon you to get a negotiation if you need one, Mr. Cross.
Okay.
Okay. Timothy Kelly. Timothy Kelly.
Also, he's got a federal case too, so I'll keep them. Okay, there's that.
We'll issue a bench for him for failure to appear. I could modify it if we find out.
Judge, he appeared, or I don't think Black's County appeared last month, actually. I don't think we can get along. But
He was on state or federal case.
Well, what do you want me to do? I mean, I didn't know that. We do our best to find them, but
I'd like to continue generally until I see what the federal case says, with my other allocated.
okay, well, let's set it out to July for review, July 14th, okay? I'd be shocked if they prosecuted anybody, but yeah. Troy Coots. Active warrant for Troy Coots. Is that correct, Mr. Stockton? Timothy. Okay. NCIC already, okay. Timothy Lawrence. Timothy Lawrence is not present. What?
We'll enter a great order of enforcement and on the case, and then I'll have to dismiss the case. So, but that's the only reason why that happened.
This is one that was dismissed. That just for the purpose of all the motion.
Isaac Lee.
He was in rehab the last time I knew him. I don't know if you've been served or not.
Yeah, he's in rehab, I believe in Bowling, where he's selling to a first court order out of Barrington.
And I ain't got.
Matthew May. What do you want to do on Isaac Lee? Continue it till you bring it back on the docket?
We have service, I guess, is my
Yeah,
question.
he was served on February the 8th.
And we have a thing, look it up.
I have no idea
I
where he
wasn't
was.
informed that he was in rehab. I had no idea.
This is just a precursor of what's fixing to happen to us with some of these new laws they passed. They're gonna put people in rehab here, there, and everywhere. We're not gonna know where they are. If we get them served, we're not gonna be able to get them here. But I guess we can just get used to it.
I'll see what I can do, like, get back on the dock.
Okay, well, I'll set it for July 14th. Or you want to set it sooner than that?
No, that's fine.
July 14th. Matthew May. Are you Matthew May? It's 21 CR 0014. Mr. May, what's your year of birth? 1987. What is the last four digits of your social security number? You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct? Is there any reason this gentleman should not be sentenced to that? On a plea of guilty to trafficking and controlled substance first degree, a class D felony, defendant shall receive a sentence of 5 years, serve 60 days home incarceration. The balance probated for 5 years supervised. The defendant shall be referred to social service clinicians and follow any and all recommendations of the clinician. And he shall receive credit for time served, but the credit for time served shall not count against the 60 days, but against the whole sentence. What is the court cost in this case?
155.
Court cost is $155. Will you need some time to pay that? Okay, I'll let you pay your first payment of $50, 30 days from today, and then 30 days every after that to get it paid in full. You need to meet with the probation and parole officer right over there. Yeah. Dakota Melton. Commonwealth, Kentucky versus Dakota Melton, 21 CR 00127. Mr. Melton, what's your year of birth? Okay, the last four digits of your social security number. Okay, you're here for pretrial conference. What do you have here?
Your Honor, we have a waiver for pretrial diversion agreement for the court to consider.
Because on April the 1st, everybody signed the Commonwealth officer.
Adair County, if you'll turn your camera off just a second, we'll get right to you, okay? A motion has been tendered, Mr. Melton, that says you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Are you the same person named in indictment number 21 CR 00127?
Yes, sir.
Okay, you understand the charge against you? Have you discussed this matter with your attorney?
Yes, sir.
Are you satisfied with his advice?
Satisfied. Yes, sir.
Do you believe you've been fully informed about the case?
Yes, sir.
You realize that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States constitutions. You have a right not to testify against yourself. No one can make you say anything. Right to speech, trial by jury, right to be represented at counsel by your jury trial, at your jury trial. Right to confront and cross-examine all witnesses, call to testify against you, right to produce evidence, or right to call witnesses in your favor, right to appeal this matter, higher court to lose, right to fight the Commonwealth, prove beyond a reasonable doubt you're guilty of charges. For entering a guilty plea, you give those charges. Now, have you previously been diverted in the last 5 years?
No, sir.
Do you have any felonies in the last 10 years?
No, sir.
Are you currently on probation? Okay, you waive your right to speed trial? Okay. Have you completely read and understand the diversion agreement?
Yes, sir.
Okay. You're now entering a plea on the diversion agreement. If you successfully complete the diversion agreement, case will be dismissed, pretrial diverted. However, if you don't successfully complete it, I can revoke pretrial diversion and sentence you. You understand that? Mr. Stockton, you want to come up? There's Roder on there. We'll do Roder, you'll be next, okay?
We refer to social service commission, receive credit for time served, pay costs at discretion of the court, maintain gainful employment.
Is that what you agree to?
Yes.
I'll sign the diversion agreement. You need to meet with the probation parole officer. What are the court costs this case?
155.
155. You need some time to pay that?
I can pay this.
Okay, well, you pay it downstairs then, okay? Thank you very much. Now, who's on the road? Okay, let's go back to Roder. Let's go back to Roder Correctional Complex. Roder, we have Commonwealth versus Richard Guthrie, and then Commonwealth versus Daniel Moreland.
Mr. Moreland's in quarantine and will not be.
Mr. Moreland has been announced as in quarantine and won't be able to appear. Is that correct, officer?
What's he saying?
He's asking about another guy. I am not sure.
Okay, are you Richard Guthrie?
Yes, sir.
Okay, Mr. Guthrie, this is 21 CR 0031. Your attorney is present here today. We're here for a pretrial conference. You're represented by, just keep those there. Keep those there. Mr. Lee Wittenberg, is there a plea here today? Is it a felony plea? Okay. A motion has been tendered, Mr. Guthrie, that says you wish to enter a plea today. Is that correct?
Yes.
Okay, Pulaski County, will you turn your camera off until we call your case? It won't be very long. Is this plea freely and voluntarily given?
Yes.
Pulaski County, will you turn your camera? Thank you. Are you the same person named in the indictment 21 CR 0031?
Yes.
Have you had plenty of time to discuss this matter with your attorney? Are you satisfied with his advice?
Yes.
You have certain rights under the Kentucky and United States Constitution. By entering this plea, you give up those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses, the right to produce evidence, the right to call witnesses to your favor, right to appeal this matter to higher court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge. But entering a guilty plea today, you give up those. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. Mr. Stockton, will you go over the recommendation of Commonwealth?
Yes, Your Honor. Mr. Guthrie will plead guilty to receiving stolen property, receive a sentence of 1 year. That'll run consecutively with Clinton indictment number 13 CR 20. He'll receive any credit for time served and pay court costs at discretion of the court.
Okay, now, is he presently a state prisoner?
Yes.
I can waive the pre-sentence investigation report. So is this what you agreed to, sir?
Yes.
You realize after entering this plea, this additional felony can be used against you on the persistent felony offender program to enhance future felony pleas. You understand that?
Yes.
Knowing that, is it still your desire to go ahead and enter the plea and let me pronounce the sentence?
Yes.
Yeah, I will waive the pre-sentence investigation report, accept the plea. I've got a document here that has your signature on it. You remember signing that document, is that correct?
Yes.
I'll accept the plea and we'll enter the sentence today, okay?
Okay.
Now, as far as Roder, thank you for your cooperation. We appreciate it very much. Did you say that Mr. Moreland was not available? Is that what y'all said?
I am not sure about him because he's not in my area.
Yeah. We were told that he was in lockdown for exposure to COVID or anything. So we'll just, there's a motion on an appeal bond. So what we'll do is we'll just try to get him on the next docket. Thank you for your cooperation. Y'all have a nice day.
You do.
Yeah. Let's see who else is on the line. Pulaski County's on the line. Let's go to Pulaski County real quickly because we just got a sentencing there. Won't take very long. Pulaski County. Commonwealth, Kentucky versus Richard Smith, 21 CR 00144. Are you Richard Smith?
Yes.
Born in 1971.
Yes.
Last four digits of social security number are 2922, Mr. Smith.
Yeah.
You had an opportunity to look at the pre-sentence investigation report done by probation and parole.
Yeah.
Is it substantially correct?
Well, besides we said I just had 3 days in custody. I mean, I've been locked up since July. Does that matter?
Okay, well, what you want to do is reserve the right to administratively challenge the number of days is what you want to do. That. Is that correct, Mr. Guffey?
And Judge, that's correct. I would also state that he has another case that he was serving on as well. So once the two cases are combined into one sentence, I would hope that your custody credit would be corrected at that point.
Okay, well, I'll let him reserve the right to administratively challenge it. Upon pleading guilty to burglary third degree, shall receive a sentence of 1 year to serve. The defendant shall pay restitution amount of $1,050, subject to clerk's fee. He shall receive credit for time served. Now, how long are you going to be in there, Mr. Smith? You
In
know?
here, I don't know.
Okay, well, what are you sentenced to?
Today's a year, today, and I got, I think, a probation violation coming.
Okay. Well, since you're gonna be incarcerated for a while, I'm gonna waive your court costs, okay? You won't owe any court costs. Okay, well, thank you very much. Now, do we have nobody else at Pulaski County today?
That's the only one I had, Judge.
Thank y'all for your cooperation. Y'all have a great day.
Thank you.
Let's go to Leslie County. Leslie County. Commonwealth, Kentucky versus Bobby Ray Phillips, 21 CR 00110. Are you Bobby Ray Phillips?
Yes, Your Honor.
We're here today for pre-trial conference. Your attorney, Mr. Sheffett's on the line. You see him there. What do you got, Mr. Sheffett?
Well, Judge, Jesse and I have been discussing the case back and forth, and I think I've made a counteroffer that he wants to talk to his complaining witness about.
Well, I talked to them this morning. We're really far apart. I don't mind doing one more pretrial date, but if we don't get it resolved, then we need to get a trial date.
Okay. Let's do a negotiation date on the 6th of May, and May 12th is the next, and we'll either set a trial that or receive a plea or set a trial that day. Is that all we have in Leslie County?
It is, that is it.
Thank you very much for your cooperation. Let's see. We've got Taylor County, you're on there. Let's do a real quick Taylor County thing. Wayne County will be you next, okay? Taylor County, Commonwealth, Kentucky versus Jesse Brown. Are you Jesse Brown?
Yes.
Okay, your birthday, 1989, Mr. Brown?
Yes.
Last four digits, social security number 8111, is that correct?
Yes.
Mr. Sheffett, what do we have here for Mr. Jesse Brown?
Judge, we have a mediation scheduled May the 5th. So I guess if we could just set him on that May docket and we'll know where we stand at that point.
We have a mediation on May the 5th. It won't be necessary then to have a conference. You could just put him back on the docket for May the 12th. That sound good, Mr. Stockton?
Yes, Your Honor.
We have nothing else at Taylor County. Taylor County, thank you for cooperation.
Thank you, sir. Have a good day.
We're going to Wayne County now briefly, and then we'll do Adair. And I guess we got a special case in Adair. Let's do it and give Mr. Stockton case, maybe if anybody needs to talk. Huh? They're not on there yet?
No, we don't have a special case in there.
Where is the special case?
Russell and them.
Russell's not on, so we can't do that. Let's go to Adair then. Adair and then Wayne. Commonwealth, Kentucky versus Brandon Hall. Okay, we got the Stubers there. Okay. Commonwealth, Kentucky versus Candy Stuber and Jonathan Stuber. On Candy, it's 21 CR 0025, 21 CR 00131, Cumberland County, which is being heard here for the purpose of convenience. On Jonathan Stuber, it's 21 CR 0024, and Cumberland case 21 CR 00130, which is also being heard here in Cumberland County for judicial economy and convenience. What do you have in this case, Mr. Stockton?
2 felony pleas, each county for each defendant.
Okay.
I mean, 1 felony plea each county for each defendant.
So what I'm going to do is I'm going to go over these things together because both of you are there. The motion has been tendered. Both of you wish to enter guilty plea today. Is that correct?
Yes, sir.
Okay. Are y'all currently under the influence of drugs or alcohol?
No,
Okay. Is this plea freely and voluntarily entered?
Yes.
Yes, sir.
Same people that are named in the indictments in Clinton and Cumberland County, which I've just read.
Yes, sir.
Is anybody, are you fully informed about the evidence in your case? And you've had plenty of time to discuss this matter with your attorney, Mr. Sheffield?
Yes, sir.
Okay, have you signed a waiver for Mr. Sheffield to represent both of you?
Yes, sir.
Okay. Do you understand that you do not have to enter guilty plea today? You have certain rights under the Kentucky United States Constitution before I can accept a plea from either one of you. I know you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require a Commonwealth prove beyond a reasonable doubt that you are guilty of charges against you. By entering a guilty plea here today, you give up those. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation and parole. Mr. Stockton, could you tell us what the agreement is?
Yes, Your Honor. I'll start with Candy Stuber and do her pleas, and then do Mr. Stuber's if I can. In the Cumberland County case on Candy Stuber, she would plead guilty to trafficking in a controlled substance, first degree, over 2 grams, receive a sentence of 7.5 years, probated for 5 years. The probation is to be supervised. She would also plead guilty to DUI first, pay a fine of $200 fine and cost, and she would be released at final sentencing. She agrees to forfeit the $500 seized at the traffic stop. Her car will be released upon payment of a $200 bill to the Cumberland County Sheriff's. When she's released, she'll obtain and maintain gainful employment. All evidence in this case, that case will be destroyed. In the Clinton County case, she would plead guilty to possession of a controlled substance, first degree, receive a sentence of 3 years, probated for 5 years. That would run concurrently with the 7.5 years in Cumberland County. She would pay court costs at the discretion of the court, have all evidence in that case destroyed. You want me to go to Mr. Stuber's?
Is that what you agreed to, Mr. Stuber?
Yes, sir.
Okay, I go to Mr. Stuber now.
Okay. In Cumberland County on Mr. Stuber, he would plead guilty to trafficking in a controlled substance, first degree, receive a sentence of 7.5 years. He would also, that would be probated for 5 years, supervised. He would receive credit for time served. He would be released at final sentencing. This sentence will run concurrently with Clinton County case number 21 CR 24. He agrees that the $500 will be forfeited and the $200 would have to be paid to retrieve their Chevy Impala. He would pay court costs at the discretion of the court, obtain and maintain gainful employment, and all evidence would be destroyed. In the Clinton County case, 21 CR 24, he would plead guilty to possession of a controlled substance, receive a sentence of 3 years. That would run concurrently with the Cumberland County case. He agrees to have all evidence destroyed.
Is that what you agreed to, Mr. Stuber?
Yes, sir.
Yeah, I'm going to, on Mrs. Stuber, I'm going to impose court costs in Clinton County of $155, but I'm going to waive the court costs in Cumberland County. And Mr. Stuber, I'm going to waive the costs in Clinton County and impose $155 in Cumberland County. That way they don't have to double up. They'll just pay one court cost instead of two. So about $300 or something like that. Both of you have heard that. Is this what you agreed to? Both of you agree to this? Is that right? Mr. Stuber, you heard what the Commonwealth said. You've agreed to this.
You could have it. Yes, sir.
Okay.
Yes.
Well, I will accept the plea order pre-sentence. You understand that these pleas could be used against you in the future if you have any other felonies under persistent felony offender law. Do you understand that?
Yes,
Yes,
sir.
sir.
Well, I see that you've signed the documents. You both acknowledge signing the documents on the plea agreements. Is that right? Yeah, I'll accept the plea request and we'll just do the sentencing here.
Judge,
Yes.
we had discussed doing the sentencing in Cumberland on the 28th, if altogether possible. That was part of the discussion, so they could be released at that time.
April the 28th?
Yes.
Okay. I have no problem if they can get, the report done by then.
Just cut through that, we'll try.
Well, probation parole, so they do their best to get the report. If they have the report done, we'll have it on the 28th. Okay? Okay, thank you very much. We got one other case up there, and it'd be Brandon Hall. And then we're coming to Wayne County.
Paperwork on that one.
Brandon Hall.
Okay.
No, he's Easter.
No, I think he's the one. I'll be right back.
Okay.
I just didn't-
I think Wayne County has several, so we're doing Wayne County next.
Yes, he was one of the ones transported to Bullitt County this morning.
Yeah, he had a plea to enter today. Well, we'll try. Did you check to see if it's at Bullitt County yet?
Yes, Yeah, they come and got him probably like an hour ago and took him to Bullitt County.
Okay, thank you very much, Adair County.
Thank you. Y'all have a good day.
You too. Wayne County. Good morning. We have Brandy Beatty.
Brandy Beatty.
Commonwealth versus Brandy Beatty, 21 CR 0018. Are you Brandy Beatty?
Yes, sir.
You born in 1985?
Yes, sir.
Last four digits, social security number 9531. Is that correct?
Yes, sir.
Docket says you're here on a probation revocation. What do you have to say, Mr. Stockton?
Your Honor, she has a 5-year sentence on, I believe it's trafficking. If I need to go get the file, I will. She absconded her probation. I didn't know if she's going to stipulate or not.
Judge, I have not talked to Miss Beatty. I did not know she was over at Wayne County. I've been over there a million times, it seems like, and I missed her. I apologize for that. I can, if we get a break, I can call her and talk to her, or we can reset it for next month.
Do you have a pen on her? She's on state dime.
Oh, she needs a pen on her, Your Honor, if we're going to continue.
I just said there's not one.
If y'all enter a pen on her, we'll schedule it for the next court day. Her attorney says that he has not had an opportunity to talk to her.
Typically without an order on the board, unless you just promise him.
Mr. Stockton, go over what you say she did as far as the revocation.
She absconded her probation. She's been absconded for some time. Miss Vanderpool's going to get the file, and I can tell you the exact date, or Mr. Martin can tell you probably out there. She just hadn't complied with her probation at all.
Well, I'll pass over her for right now. And we'll come back to her. Deborah Bell. Deborah Bell. Commonwealth versus Deborah Bell, 19 CR 0087, 21 CR 00116. We have a pretrial conference on 116 and a probation revocation on 1448. What does Commonwealth have to say?
My understanding is she's going to enter a plea on 21 CR 116 for 1 year to serve and stipulate revocation in 19 CR 57.
That's
Ma'am,
correct, Judge.
A motion has been made that says you wish to enter a plea today. Is that correct?
Yes.
Ms. Bell, is that correct?
Yes.
Okay. Are you currently under the influence of drugs or alcohol?
No.
Is your mind impaired in any way? Do you know what's going on here?
Yes.
Have you had plenty of time to discuss this matter with your attorney and you feel like you're fully informed?
Yes.
Okay, you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. The right to speak trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of the charges against you. When you're guilty plea today, you give up those rights. Now I may consider the Commonwealth's recommendation, which you just heard, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll have a pre-sentence investigation report done by probation bureau. In the event that I decide to give you more time, I'll allow you to withdraw your plea. You understand that if you enter, by entering this plea today, that you become subject to persistent felony offender law. If you have a felony in the future, it could be enhanced or you get more time because of this plea. Do you understand that?
Yes.
Are you satisfied with your attorney's advice?
Yes.
You pleading guilty because you are guilty for no other reason?
Yeah.
Okay, I'll accept the plea. And is she a state prisoner now?
Yeah. No, I'm county.
Well, she will become state with this stipulation on 19 CR 57.
Yeah, but I still can't waive the pre-sentence investigation report because she was not a prisoner today when I sent her. So I'll order a pre-sentence investigation report, have her back here on May the 12th, and the revocation goes in effect today, and then the sentence on the new thing will be on the 12th. Okay, thank you very much.
Well,
Benjamin Claywell.
Who made his file?
Benjamin Claywell.
Yeah. So I need Brandy babies. Yeah, I'm good.
I sent an email to that link asking to confirm the there.
Yeah, yeah, if you would, just tell him that he was scheduled to enter a plea here today and we need to Zoom. We need to get on Zoom. Okay, thank you. You might call a Russell County jail over there and see if they'll get online for your special case. We're glad to have you here, but I'm sure there are other places you'd rather be. Did I call Benjamin Claywell? Commonwealth versus Benjamin Claywell. Good morning, Mr. Claywell.
Morning, Judge.
This is 21 CR 0088, 21 CR 0089. Mr. Sheffield, your attorney, is on the line here. Mr. Stockton, what's the situation here?
We have paperwork for a felony plea, Your Honor, with the alternative sentence.
Okay. Mr. Claywell, a motion's been filed that says you wish to enter a plea. Is that correct?
Yes, sir.
You're currently under the influence of drugs or alcohol?
No, sir.
It's pleaded freely and voluntarily given.
Yes, sir.
You're the same person named in indictment number 21 CR 88 and 21 CR 89. Is that correct?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you had plenty of time to review the evidence and are you from and discuss this with your attorney? Are you satisfied with his advice?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I want to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Matter you're guilty plea, now you give up all those rights. Now, I consider the Commonwealth's recommendation, but I also may apply any range of sentence provided below. I don't have to accept their recommendation. Prior to accepting the recommendation, I'll wait to pre-sentence investigation report from probation and parole. And if I do not accept it, decide to impose a harsher sentence. If you do not agree with that, I'll give you an opportunity to withdraw your plea and go to trial. What is the Commonwealth's recommendation, Mr. Stockton?
Your Honor, upon a plea of guilty in indictment number 21 CR 88, he'll plead guilty to fleeing, invading first degree, motor vehicle, and persistent felony offender second degree for a total sentence of 10 years. In 21 CR 89, he'll plead guilty to possession of a handgun by a convicted felon, a sentence of 10 years. He'll also plead guilty to trafficking in a controlled substance first degree, receive a sentence of 10 years. The two 10-year sentences shall run concurrently in that case. The 10-year sentence in 21 CR 88 and the 10-year sentence in 21 CR 89 shall run consecutively for a total of 20 years, with the balance probated for 5 years supervised. He'll enter and complete the Clinton County Specialty Program. He has, as of today, 231 days in jail. He shall remain in custody until final sentencing or drug court orientation. Once he's released, he shall have an additional 180 days home incarceration, wear an ankle monitor, shall be permitted to go to work, church, doctor's visits, specialty court, or take his mother to her doctor's appointments. He'll receive credit for time served. He'll forfeit the handgun and also pay any storage fees as regards a Chevy Blazer registered to Jimmy Porter. He'll remain on active supervision until all court costs and fees are paid. He'll obtain and maintain gainful employment, and all evidence in this case will be destroyed.
Is that what you agreed to, sir?
Yes, sir.
Okay, I will have an order of pre-sentence investigation report to be done by probation and parole. We'll be back here on May the 12th for sentencing. Have all the documents referring to the special court been, if they're presented to me, I've got them.
They should be in the file, I think, Judge.
They just showed them, yeah.
You signed the referral, drug court referral yesterday.
Yeah, I've been informed that it was in the drug court referrals from yesterday, so.
Judge and Mr. Commonwealth Attorney, would it be possible to allow Benjamin to begin his home incarceration immediately? I mean, rather than serve in custody until.
I'll let you talk to Mr. Stockton about that.
Well, I'll just say, Your Honor, I make an agreement and I stick by it. So we've made the agreement, and if he wants to withdraw the agreement, we'll go on with the trial.
That's what I'm saying. This is the agreement, and if there's any modification of the agreement, he'll have to come to you, talk, and give you some special reason. If you agree with that, I'll consider it, okay?
It was just a request, gentlemen.
Yeah,
thank you.
Just an answer.
And I want to add too, that the offer and the entry plea hasn't been signed by the public defender.
Yeah.
So that.
Yeah, I need to sign those. I need to sign the documents, Judge.
Okay, you understand it about the persistent felony offender law, sir, because, you know, you've previously been, is that correct?
Yes, sir.
Okay, well, I'll accept the plea and set that date there and May 12th and make sure all of the documents. While we still are doing this, could you take that back there and let the public advocate sign that? Okay, Tanya Kanatcher next. Commonwealth, Kentucky versus Tanya Kanatcher. 21 CR 0021, 21 CR 0077, 13 CR 0012. Russell County, I'm glad that you're on there, but will you turn your camera off just for a second and I'll get to you the next case, okay? Commonwealth, are you Tanya Kanatcher?
Yes, Your Honor.
Okay, Ms. Kanatcher, you're here today for a pretrial conference, sharp probation revocation, and on 2 different cases. You want to go back there and use the camera so you can.
A little complicated, John. Brad's got her on the new case and I've got her on the revocation. I have to go back and
Yeah, well, if you want to be on camera, you need to. Okay, Mr. Stockton. What do
Your
you
Honor, I
got?
may be in error. I thought 21 CR 121, and she been arraigned on that case.
I don't know, it says pretrial conference on here.
I thought it was for arraignment. I may be a month behind.
Arraignment was on March the 3rd.
March the 3rd, she was.
Okay. Okay. Well, I guess I need a trial date on 21 CR 121 unless she wants to stipulate on these other cases.
Your Honor, as I said, Brad represents her in the new case, and he and I have not talked about the facts in the new case. It may well be in her best interest to do that, and it may not, I don't know. But in the interest of being fair to Ms. Kanatcher, I'd say Mr. Shuffett and I need to discuss the facts of the new case.
Hey, well, I'll give you some chance to talk. I'm going to Russell County now, and you just go off camera and discuss it. We'll be right back to you. Let's go to Russell County briefly.
Have you not been appointed? Okay, I don't think you have either because, yeah.
I don't really know what's going on.
Your Honor, Brad's not been appointed yet, it's what he says.
He has now.
You have now, Brad. There's a new indictment. To explain, Your Honor, I advised the court previously, I didn't know if I'd be representing Tanya on the new case.
I don't need to know about that. Okay.
But I had told Mr. Stockton.
Brad's representing her in the new case. You're representing her in the old cases. So y'all want to talk about it, and I'll come back to you, okay? Let's go to Russell County. Now, which case do you have in Russell County? Okay, let's come around here and get that. We'd like to call up Chris Thrasher. Let's turn the camera off in Wayne County, please.
I up here, Your Honor.
Chris Thrasher.
It just blows our voice is not.
I mean, they are.
Commonwealth versus Chris Thrasher, 20 CR 0087 and 21 CR 00114. Are you Chris Thrasher?
Yes, I am.
1982.
Yes.
And it's 4-digit social security number 2940.
Yes.
What does the Commonwealth have to say in this case?
Judge, I think we're in the trial.
Okay. Well, we'll probably do 2 long days, you know. What about jury selection? Have you thought about jury selection to think of either one of you? Or does this venue okay with both of you? Okay, how about you? Okay. No, we won't ever know that till the end of the year. All right. Yeah. Are you going to select a number of counts, or are you going to try them on 152 counts? You don't have to make that decision today. Well, that's a prosecutor decision that you'll have to make. Yeah. Let's go out.
I got out. This guy's still here. But
Yeah.
Somebody's got a live mic on there. Could we check and see who that might be? It's not Russell County. But it's okay if it's Russell County. Let's. Let's try this on the July the 18th through the 20th. That gives us 3 full days. Right.
Two cases. At what point is the court?
Well, one of them is actual conduct and the other is a possession case. Is that right?
Yes, sir.
Okay, well, you'll need to, I would think a couple of months out, probably. I think this is in July. Maybe May the 16th, would that be reasonable? Okay, the 16th, okay. And I guess if you have any pretrial motions, we need to cut them off at some juncture. Give us a little time. Probably that would be June the 9th would be the last pretrial motions we might have on that, okay? Okay, well, thank y'all very much. Yeah. Sure, be careful. Absolutely. At least you don't have to go over the 127 like he does.
It's not bad.
Not as bad as it was.
Yeah,
Yeah, that's good. When the bridge is built, it'll be better. Okay, so yeah. Okay, while we're at Russell County, let's just go ahead and do Timothy Brown. Timothy Brown.
Also on Timothy, or whoever you're doing that on.
I wrote it.
On a drug court order?
Your Honor,
I'll just go there now.
Yes.
we can't have him around other inmates. Can we please take him up last?
That'd be great. Barbara Johnson then. Commonwealth versus Barbara Johnson. Are you Barbara Johnson?
Yes, sir.
Okay, your counselor, Mr. Coleman Hurt's on the line here. This is him there. Wave, Mr. Hurt. Okay, Mr.
Yes.
Stockton.
Yes.
Okay.
Oh, don't have my video on. Okay.
What do you have? This is Barbara Johnson, 21 CR 00113. What do you have in this case?
My understanding is she's going to enter a plea or be sentenced in Warren County, and Mr. Hurt wanted one more time to enter the plea next time, and I'm in agreement.
That's right, Judge. She's
May
entering
the
a.
12th, May the 12th.
Okay, thank you, Judge.
Okay.
Thank you.
Yeah, William Perdue.
Yes, sir.
William Perdue, 21 CR 00130. You William Perdue?
Yes, sir.
In 1971.
Yes.
Last 4 digits, social security number 7571. Is that correct?
Yes, sir.
Okay. What do you have here?
Judge, Willie's a state inmate at this point. There are some, I need to make sure I've got the right tapes, the right discovery. I need to get with Commonwealth and maybe review if they've got.
Put it back on the docket for May 12th.
Yeah.
You want a negotiation day before then?
Please.
May the 6th for negotiation, May the 12th. For the next court appearance. And now we're down to, your attorney will be in contact with you, sir, okay? Now we've got Timothy Brown, our last person, Russell County. We'll go back to Wayne County.
Thank you, Your Honor.
Yeah.
Yeah, Clinton County Jail.
I will. Your Honor, it'll take us just a minute. We have to cuff him and everything to get him up here. So it'll be just a few minutes, okay?
That'll be fine.
Thank
Let's
you.
get back, will we finish with Tanya Kanatcher? Okay, I'll go back to Wayne County Jail and y'all can turn Tanya Kanatcher's camera back on. Yeah.
Who?
Sherman Hensley.
Piddling.
Yeah.
He did do better in drug court.
Okay. What do we have, this Miss Kanatcher back? What do we have on her?
Judge, the Commonwealth has just provided me discovery on the case. I wasn't previously involved prior to today. I'd ask the court to set it for May and give me a chance to look at it and go
May
from there.
3rd, May 3rd, and no, excuse me, May 6th and 12th.
And she needs a pen entered on her on those old cases, Your Honor.
If they would.
Possibly get a bond.
We would do order, we would always request with Carson an alternate sentence. So pending revocation. I don't know if you can do it.
Well, I'll just request a trial date if we don't resolve it on May the 6th, a quick one.
Yeah.
Mr. Stockton, I'm going to stay in the other cases, but Brad and I will talk in the next few days.
What case are you on? You last time you were here for arraignment, but you hadn't been retained on the new one. So now you're staying on the two older ones. Is that what you're saying, Mr. Cross, the 12?
Your Honor, I'm still attorney of record on the revocation. I advised the court and the Commonwealth that I had not yet been officially retained on the new case and entered a limited appearance. And then prior to the negotiation day, I told Mr. Stockton that I was not being retained on the new case. So that's why Brad wasn't involved.
I understand that. Yeah.
But Tanya, I'll still be attorney of record on these revocations, so I'll talk to you too, okay?
Well, my mom, she's sick. She's got dementia and she's trying to take care of a 17-year-old and a 7-year-old. He graduates kindergarten in May. And if I could get home incarceration, drug patch, whatever, I'm not feeling no drug test since I've been home, Your Honor. None.
It's not time to talk about that. They'll be calling you talking about it, okay? Okay. The next case,
Well, I'm still just here.
Been selling drugs when she's out before.
Well, I was going to say it, but I'm not going to.
have y'all got Timothy Brown there yet in Russell County?
Your Honor, we're trying to get him up here right now, okay?
Okay, well, I was just going to try to accommodate. I guess Travis Flowers, let's go back to Wayne County, Travis Flowers.
We don't have Travis Flowers.
Okay. Does anybody know where Travis Flowers is then?
He's at Clinton County, I think.
Okay, well, we'll move him back down to the Clinton County docket. Marzanka Neal. County. Yeah, who was the person? What county were they? The Dare County. In the case of Commonwealth versus Brandon Hall, who was moved up to E-Town, is that right? Was moved to Bullitt County. Bullitt County will not allow us to see him today because it's too short a notice. They just got him up there, but just getting him up there maybe now. So we'll continue his case until May the 12th, Brandon Hall. Marzika Neal. How you say your first name, Miss Neal?
Marzinka.
21 CR 00128. We're here on a pretrial conference.
Your Honor, we have she's supposed to stipulate her revocation in 20 CR 52 and take a felony plea in 21 CR 28.
128 or 28?
I may have wrote it down wrong, whatever it is. It's 128, 128.
Okay, a motion has been filed, Ms. Neal, that says you wish to enter a plea. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
No, sir.
Okay, is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that is named in 21 CR 00128? Is that you, the same person that's named in the indictment as you, correct?
Yes.
Okay. Have you discussed this matter with your attorney? Have you reviewed all the evidence and are you satisfied with his representation?
Yes.
Okay. Now, before I can accept the plea, I need to know that you understand the rights that you have under the Kentucky and United States Constitution. I'm going to go over those rights, and to end them, I'm going to ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to cross-examine and confront all witnesses that want to testify against you, the right to produce evidence, the right to call witness yourself, and have process issued to compel attendance. You have the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Rather than a guilty plea here today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept their recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation and parole. In the event I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, I will inform you that I'm rejecting it. And if you don't want to go along with a harsher penalty, you can withdraw your plea. Do you understand that?
Yes, sir.
Okay. Mr. Commonwealth Attorney, will you state and listen very carefully to this offer? Go ahead, Mr. Stockton.
Your Honor, in 21 CR 128, she'll plead guilty to trafficking in a controlled substance, first offense, first degree, receive a 2-year sentence. She would pay court costs in discretion of the court. That would be consecutive to 20 CR 52, in which she would stipulate the revocation of her probation. All evidence in the case at hand would be destroyed, and she would pay court costs at discretion of the court. She would have a total sentence of 7 years.
Is that what you understood?
Yes, sir.
Okay. Has anyone, including your attorney, offered you any or threatened you in any way to get you into this plea, or are you entering a plea because you are guilty?
I'm guilty.
Okay. You're what?
I'm guilty. It's
Okay. That's it. Okay. Now, I've explained your constitutional rights to you. Know your constitutional rights. You desire to go ahead and allow the court to fix your punishment according to law. Okay, I will accept the plea. And you understand by entering this plea that future convictions under persistent felony offender law your sentences could be enhanced. Do you understand that?
Yes.
Okay. Did you sign the document that we have present here today? Is that correct? Okay, I will accept the plea, order pre-sentence investigation report, and have your sentencing on May the 12th, okay?
Okay.
Probation Pro will be in contact with you. Since the amount of time is involved, I'm going to waive your court costs, so you won't have any court costs, okay?
Thank you.
Okay, thank you very much. She's in Wayne County, but I can't promise you where she'll be tomorrow. Sierra Piercy.
I think they've got Mr. Brown on, Your Honor, in Russell County. We probably ought to take him up.
Okay, let's go back to Mr. Brown then. Commonwealth versus Timothy Brown, 22 CR 00022. Are you Timothy Brown?
Sir, I'd like to fire my lawyer, though. I'd like to represent.
Let me get you ready here. I'll give you a chance here just a second. Were you born in 1988?
Yes, sir.
Last four digits, social security number 7076.
Yes, sir.
You're here for the purpose of arraignment. I'm gonna let your lawyer stand in for the arraignment, and then we'll talk about the representation. The grand jury of Clinton County has returned an indictment charging you with assault, third-degree assaulting a correctional officer. Mr. Sheffield, you acknowledge the identity of your client, received the indictment, wait for more reading arraignment, and your plea not guilty. Okay, now you have a right to remain. You have a right to remain silent, Mr. Brown. But if you want to waive that right, I'll listen to what you have to say here.
I would just like to get rid of my lawyer. I really just don't like that guy at all. I'd probably have a better chance without him.
Well, you want an opportunity to get another lawyer?
No.
Okay. Well, I'm going to say that you knowingly waive the right to have counsel, and this will let you.
We just need to, if he's going to represent himself, I'm not going to deal with him. We just need a trial date.
Okay, we'll be fine. We'll set a trial date.
Judge, just to be clear, I'm relieved from the case.
Yes, you are.
For the record, I will mail the discovery that's been provided me to the defendant at the Russell County Jail.
And Your Honor, we'll need to set up a time for a Feretta hearing too, to see if he's capable of representing himself.
I'm definitely capable of representing myself. What are you trying to say?
No, he's not trying to say anything. It's the law that we have to get it on record for your protection to make sure that you're knowingly doing this sort of thing. Some people do what you're doing that aren't that way. So the law is established. So we have to get it on record, ask you some questions and make sure you are competent to do that. Okay.
I'm definitely competent to do that.
We got to have a hearing. You could very well be. Nobody's challenging that. It's just the way.
Well, it sounds like he was challenging it.
He's not challenging it. Okay. We'll have the hearing. Let's see here. We have it on May the 12th. And
that'd be fine.
And then we can have I was thinking we could, what about that Monroe County trial on May the 17th? Is that going to go Commonwealth versus Smith?
As far as I know, that's Johnny Bell's case. He wanted a trial date. He didn't want to negotiate the case.
That was 2 days there. So
yeah, Tommy Smith is who that is.
Yeah. And on the 24th, we've got Shad Turner over there.
That's Mr. Broderick's case, and they didn't want to negotiate it either. They just wanted a trial date.
Okay. Well, I'm going to get this gentleman a trial as soon as we can here. So we can't do it in April.
You'll never.
Oh, let's get him a trial date on what is June the 8th look like for you, Mr. Stockton? That's the day before the rule day here. Mr. Stockton, your microphone's off.
That's fine with me, Your Honor.
Okay, I'll set a trial date of June the 8th. Okay, it'll start at 9 and I'll do a transportation order to get you over here. And then yeah, he'll be transported next. He'll need to be transported for the hearing. For the hearing as far as competency remains. So I do 2 transportation orders. Y'all need to be doing, send it to us. Since he's not represented by council, if Commonwealth will do those transportation orders, it'd be appreciated.
We'll do it and make sure there's adequate safety arrangements.
Okay, thank you very much. That concludes our business, I guess, at the Russell County Jail. Thank y'all for cooperating today.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, let's go. I guess we're back to Wayne County now. Is that correct? Sierra Piercy. Sierra Piercy, Commonwealth versus Sierra Piercy, 20 CR 0056. You Sierra Piercy.
Yes, sir.
You born in 1997?
Yeah,
What are the last 4 digits of Social Security number?
9762.
Okay, we're here. It says on a probation revocation. What do you have to say, Mr. Stockton?
It's 12 months on a misdemeanor and she absconded, and it's my understanding she's going to stipulate to the revocation.
Mr. Sheffitt?
Judge, that's correct.
Okay, well,
We tried drug court and that didn't work.
okay, well, I'll just impose a sentence then. Thank you very much. Wesley Raines. Commonwealth versus Wesley Raines, 21 CR 0028. You Wesley Raines?
Yes, sir.
Wesley Raines, okay. We're on a diversion revocation. What do you have to say, Mr. Stockton?
As soon as I get the file, no, he's had a 3 years pretrial diverted for 5 years. And I probably need Mr. Martin's handling that. He would need to testify.
And Judge, this is one that slipped I don't know when he was picked up or how long he's been at Wayne County, but I missed him over there. I know that Mr. Stockton did mention possibility of drug court for Mr. Raines as well, just in speaking to him on one of our negotiation days.
Well, if he wants to do that, we can have him assessed. If he doesn't, we'll proceed. Well, I look at it.
Yes.
Okay.
Okay, well, I'll sign a referral, get one to drug court, and we'll continue it till we make determination on that. Okay, advance that. I think it'd be a good deal for you, Mr. Raines. Gives you an opportunity to avoid something twice. Most people don't get that. So, okay, they'll be in contact. Chris Sanders. Chris Sanders. Commonwealth versus Chris Sanders, 21 CR 00106, 22 CR 0031. Are you Chris Sanders?
Yes.
Okay, we're here for an arraignment on one of the cases.
And Judge, there'll be a plea in that Cumberland County arraignment.
So Cumberland County arraignment. We got a copy of it here. Cumberland Circuit Court meeting in special session here in Albany, pursuant to agreement of parties. Grand jury of Cumberland County has indicted Chris Sanders of trafficking and controlled substance in the first degree, first offense. Possession and use of radio capable of sending police signals. And possession of drug paraphernalia. Mr. Sheffitt, I'm sending that back to you there. If you'll acknowledge the identity of Chris Sanders, receipt indictment, waive formal reading and arraignment, enter plea of not guilty. Reserving all the motions. Now, I understand we have a guilty plea today. Is that correct?
Yes, Judge. Yes. Both cases.
Both cases. Well, for the purpose of judicial economy, I'll just go down through this sort of thing, understand it applies to both cases in their separate judgments. Are both cases mentioned in the plea agreement?
Yes, Your Honor.
Not a resolution, they are, they're to run.
I know, they're just mentioned, is what I'm saying, yeah. A motion has been tendered that says you wish to enter a guilty plea today, Chris Sanders, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Okay, are you the same person named in indictment number 21 CR 00160 in Clinton County and 22 CR 0031 in Cumberland County?
Yes.
Have you discussed these charges with your attorney? Are you fully advised about your case? Are you satisfied with his advice?
Yeah.
Okay. You understand that you do not have to enter a guilty plea in this case. I have to explain your rights to you here, and after it's over, I'll ask you if you understand your rights under the Kentucky United States Constitution. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at all stages of the trial, right to confront and cross-examine all witnesses called to testify against you, the right to introduce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of the charges against you. By entering a guilty plea, you give up those rights. Do you understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting a recommendation, I'll await the pre-sentence investigation reports from probation parole, which will be the same report, but it will apply to the case in Clinton and the case in Cumberland. In the event that I do not accept the Commonwealth's recommendation, decide to harsher sentence, I will give you an opportunity to agree to that or withdraw your plea and have a jury trial on either or both cases. You understand the Commonwealth's recommendation?
Yes.
Now listen very closely, Mr. Stockton.
Your Honor, Mr. Sanders, in the Clinton County case, 21 CR 106 would plead guilty to trafficking in a controlled substance over 2 grams, receive a sentence of 6 years to serve. The Commonwealth will oppose probation and shock probation. This will run concurrently with Cumberland Circuit Court case number 22 CR 31. He will agree to forfeit the $600 seized by the Clinton County Sheriff's Department in this case. Once, and he'll pay court costs at discretion of the court. All evidence in this case will be destroyed. In the Cumberland County case, 22 CR 31, Mr. Sanders will plead guilty of trafficking in a controlled substance over 2 grams, receive a sentence of 6 years to serve. Commonwealth will oppose probation and shock probation. It will run concurrently with Clinton Circuit Court case number 21 CR 106. He will agree to forfeit the police radio to be destroyed with accordance to the law to the Cumberland County Sheriff's Department. He'll pay court cost discretion of the court, and all evidence in this case will be destroyed.
Is that what you agreed to, sir? Is that what you agreed to?
Yes.
Okay. And you are doing that because you are guilty and not for any other reason?
Yeah.
I will go ahead and accept the plea. And you realize that these could be used against you in the future if you ever have any other felony conviction or persistent felony offender law. You'll understand that, right?
Yes.
Let's go ahead and have the sentencing here since Cumberland County is too soon to do that. So sentencing will be on May the 12th here in Clinton County for both cases. You do acknowledge signing this agreement. We have a copy of it here in the record. Is that correct?
Yes.
Okay, that'll be fine, and we'll see on that date. Thank you very much. Joseph Wallace. Joseph Wallace.
Did you say Crystal Wallace or Jesse Wallace?
Joseph Wallace.
Joseph. We don't have a Joseph Wallace.
Oh, you got Wallace?
He's here in Clinton County, Your Honor.
Okay, does Wayne County have anybody else for us there?
Nobody else except the first one. Did you want to see her again?
Man, I'm muted. Randy Beatty.
Oh, they call him Beatty back.
Yeah. That's yours.
Yeah.
Brandy Beatty, 21 CR 0018. What do you have on this now, Mr. Sheffield?
Your Honor, there's no change. If I think Mr. Cross has a case coming up, I could call while you take his case up. But I haven't, honestly, I would prefer to postpone it so I could meet with her and review the file in more depth.
Go over the allegations again, Mr. Stockton.
Let's see.
I will say that this was a late add-on because the Commonwealth was.
She was placed in long-term treatment around January of 2021 due to a revocation being held. She had opiates, meth, benzos, marijuana in her system. That was in January 13th of 2022. She was supposed to go and enter complete treatment. She was to enter Skyhope recovery. She was discharged on January 29th, 2022, because she left the program against the staff's advice. And we've been looking for her, had to put her in NCIC ever since.
Okay, I've been informed that this was a late add-on because we weren't aware of the fact that she had been served. So
that's correct. I had it added on, you know.
Mr. Sheffield, have it back here on May the 12th, but I will consider an agreed order of revocation if you want to get her on the path before then. If you can't, we'll hear it on May the 12th. Okay. And that finishes Wayne County for us there. Thank you for cooperation and apologize for any delay or inconvenience you had. Okay. Thank you very much.
Wallace next or not?
Clinton County Jail.
Could be Eminette, your guy Eminette too.
Mr. Wallace. Hello.
Where's Wallace? Joseph Wallace. That was Travis.
You know, I kept anything what he says, I can hear.
Sir, you want to identify yourself?
Joseph Wallace.
Okay. Commonwealth versus Joseph Wallace, 22 CR 0017. Mr. Wallace, was your year of birth 1976?
Yeah.
What are the last four digits of your social security number?
4673.
We're here today for the purpose of arraignment. You have a right to remain silent. Grand jury of Clinton County's return of indictment, charging you with trafficking in controlled substance first degree, possession of a handgun by a convicted felon, possession of marijuana, possession of drug paraphernalia, possession of controlled substance in the second degree, being a persistent felony offender, it's the trafficking. Mr. Bailiff, will you hand this back to Mr. Cross back there? Mr. Cross, you acknowledge the identity of your client and the receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
We'll schedule a conference day on May the 6th.
Your Honor, if I may interject, Mr. Stockton and I have a agreed order subject to the court signing off for Mr. Wallace to go to rehab.
And on the 12th is the next court date. Now, what do y'all have to say now?
I was trying to explain, Your Honor, that we have an agreed order for Mr. Wallace to go into a 6-month rehab. That's been tendered to the court, I believe, and you indicated from what I heard, you wanted him to be arraigned first. So the May date wouldn't work.
It is always good to have someone before the court before I enter an order concerning.
Well, I didn't expect the rehab would alleviate him making his court appearances either.
Yeah.
Well, we're fine. That's fine. They've got a bed for him now, so that's.
Well, there were just a couple of days between, so everybody, this is fine.
Otherwise, I just need to put everybody in rehab and retire, I think, if we're not
Well,
gonna have court.
Well, that's coming.
It's coming, yeah.
It is, yeah. Mhm. But in any regard, Your Honor, it's, I believe, a 180-day minimum term for him. So I didn't know if you wanted to adjust the next court date because of that.
I think you're putting him in rehab. You need to have him available by Zoom or some way. It ought to be your responsibility. You're
We can do
creating
that.
this mess.
That's fine. That's
Yeah.
fine.
Okay.
Your Honor, they are coming down to sign the bond in a bit. If the court can get that order entered, we'll get him out
I'll
of
do
here.
my best. I'll
Thank
do
you,
my
Judge.
best. Let's just, everybody stop everything else here. Yeah, all the rest of y'all people waiting here, just stop till we get this done for this guy here. Is that okay?
There's not a tender order to file, it was on the email to me, so I don't.
Okay, we don't have a copy of it here. It was emailed. So if you'll send one to the clerk's office, it'd be fine.
Thank you, Your Honor.
Yeah. Now, Billy Eminette. Billy Eminette.
Yes.
Commonwealth versus Billy Eminette. Are you Billy Eminette?
Yes, sir.
Okay, were you born in 1967?
Yes, sir.
Last four digits, social security number 4269. Is that right?
Yes, sir.
Okay. What does the Commonwealth have in this case, Mr. Stockton?
It's supposed to be a felony plea, Your Honor.
A motion has been tendered that says you wish to enter a plea today. Is that correct, Mr. Eminette?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Okay, are you the same person named in the indictment that I called just a few seconds ago?
Yes.
Have you discussed this matter with your attorney? Have you reviewed all the evidence and are you satisfied?
Yes,
With
sir.
representation? Now, you don't have to enter a felony plea in this case or any case. You have a right, certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a
I do.
right not to, well, I'm going to have to go over to you. I mean, I'm sure you do, but let me go over with you. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at jury trial, the right to confront and cross-examine, call, testify against you, right to produce the evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. When entering a guilty plea today, you give up those rights. Do you understand?
Yeah.
I may accept the Commonwealth's recommendation, but I may apply harsher penalties. So I want you to listen very carefully to what the Commonwealth has to say. Mr. Stockton.
Yes, Your Honor. Mr. Eminette in 21 CR 85 would plead guilty to the charge of theft, unlawful taking over $500, receive a sentence of 4 years to serve. Commonwealth opposes probation. There'll be a $1,300 restitution assessed to him. We'll submit that in a forfeiture order. He'll receive credit for time served, pay court costs at the discretion of the court.
What are the court costs?
$155.
$155 court costs. Allow you to start paying it 30 days after you get out. $30 a month. Now you understand that once you enter this plea, you'll be a convicted felon on these two charges here, and any future convictions you have, the sentence could be enhanced with persistent felony offender law. Do you understand that?
Yes.
Okay, you're entering this guilty plea because you are guilty and for no other. Is that correct?
Yes.
Knowing the rights I've explained to you, is it still your desire to go ahead with your plea and allow the court to fix the punishment within the range permitted to law? There's documents here purported to be your signature. Did you sign those documents?
Yeah.
Okay, well, I accepted order pre-sentence investigation report, May the 12th sentencing. Okay, thank you very much.
Thank you, Your Honor.
Billy Brown. Bill Brown. Commonwealth versus Billy Brown. Are you Billy Brown?
Yes, sir.
22 CR 0020. Mr. Brown, were you born in 1968?
Yes, sir.
Last four digits, Social Security 9932.
Yes.
Okay, you're here today for the purpose of arraignment. Your attorney's on here. You have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with possession of drug paraphernalia, trafficking a controlled substance in the first degree, and trafficking a controlled substance in the first degree, first offense. Will you take these back to Mr. Sheffield, please? Yeah. Mr. Sheffield, you acknowledge the identity of your client, receive the indictment, waive formal reading, arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
You'll be here on May the 6th for negotiations and May the 12th for your next court appearance.
Your Honor.
What is Mr. Brown's bond?
Yes.
What is the bond? Is pretrial in there?
Excuse me.
Yes, it's a,
Janessa, what is?
it's a $20,000 surety, clerk approved.
20,000 surety, clerk approved?
Yes, with an ankle monitor and the standard curfew.
Mr. Stockton,
Yes,
what do you have to say about that bond?
sure you would have set an appropriate bond. Let me see, let me look at the file real quick.
20,000 property bond, with the ankle bracelet with all the other conditions I usually put on.
It was a
Surety
surety
bond.
bond, wasn't it, Janessa?
Yeah,
Yeah.
it's surety. He's high on the FTA scale. I think that might have been the cause for the ankle monitor.
Well, how many FTAs does he have?
He has 2 in the past 2 years. And then
I'd
more
ask for
else
bond
outside
hearing
of
if you want to lower it.
Yeah, you can schedule a bond hearing if you want to. Okay. Joseph Cope. Commonwealth versus Joseph Cope. Are you Joseph Cope?
Yes, sir.
21 CR 0016. Pretrial conference, Mr. Cope, were you born in 1984?
Okay.
Yes.
Last four digits, Social Security number 7467.
I didn't understand that.
Last four digits of your Social Security number 7467.
Yeah.
Okay. We're here for a pretrial conference.
Okay.
Mr. Stockton.
Yeah, we have a plea, Your Honor.
Okay. Was this a felony plea or?
Is it a diversion or felony? Diversion, I thought it was.
Motion's been tendered, sir, to say that you wish to enter a diversion plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
Sure.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in the indictment that I announced a few minutes ago, 21 CR 0016?
Yes.
Is your judgment impaired today in any way?
No.
Have you had plenty of time to discuss this matter with your attorney, and are you familiar with all the evidence in your case? Are you satisfied with his representation of you?
Yes, sir.
Okay, you understand that you do not have to enter a guilty plea today, and I need to go over your constitutional rights. I'm going to ask you if you understand them. You have the right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. The right to witness, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to acquire the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. By entering this guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may look at Commonwealth's recommendation, but I may apply any range of sentence provided by law. I have a few other questions I have to ask you because it's a diversion. Have you previously been diverted in the last 5 years?
No, sir. Not that I know. Of. Nothing.
Okay, have you had any felony convictions in the last
No.
10 years? Are you
No,
present
sir.
on probation?
No,
Do you
sir.
waive- Yeah, do you waive the right to speedy trial?
Yes, sir.
Have you carefully reviewed the diversion agreement with your attorney? And do you understand all of that and the obligations you have under it?
Yes, sir.
You understand if you violate the diversion agreement, you can be brought back before the court, have your diversion agreement voided, and then I would order a pre-sentence investigation report to be done by probation and parole. You'd be sentenced, you'd be a convicted felon that can be used against you in future convictions to enhance your sentence. You understand that?
Yes, sir.
Okay, so it's your desire to go ahead and enter a plea on this case and subject to the diversion, is that right?
Yes, sir.
Accept the plea, what would it cost in this case?
$155.
$155. I'm gonna give you some time to pay that. Your first payment will be due 30 days after you're released from jail, and 30 days out every other month till you pay the $155 that's involved. I will accept the offer of the agreement. That is your signature on there, and you've completely read it, right?
Yes, sir.
Okay, well, I'll enter that and they'll take appropriate actions with it. He'll be released today.
Yes, that's what I'm supposed to.
Well, you won't be released today or you won't wait?
Yes, sir.
Okay, well, I thought that was right. I was going back and asked you, go back to the part where they asked you if you knew what was going on or not. If you said.
Yeah, I just felt like I was supposed to be, I reckon.
Okay. Okay, well, listen, man, I hope things turn around for you, straighten up, okay? Okay, Sherman Hensley. Sherman Hensley.
He's still with his lawyer, Your Honor.
Okay, Timothy Harrell. He was with his lawyer, I don't know. I'm gonna chef it's the rest of them. Identify yourself, please.
Timothy Harrell.
Commonwealth versus Timothy Harrell, 21 CR 00115. You Timothy Harrell,
Yes, sir.
born in 1985.
Yes, sir.
Last four digits of your social security number 0085.
0095.
Okay, we'll make note of that change. It was on the docket wrong, probably just a typo. We're here for a pretrial conference. What do you have to say in this case, Mr. Commonwealth Attorney?
For some reason, we've not been making any progress in this case. I don't know what's going on. I know Mr. Hurd has the co-defendant, Barbara Johnson. We put her off for a month because she had Warren County charges.
Mr. Sheffett, you want to accept responsibility for lack of progress, or you have your alternative view of this?
I don't necessarily have an alternative view of it. I think ultimately, I don't know if the court or the Commonwealth wants to wait and see what Miss Johnson does in terms of entering a plea.
I don't think what she does is irregardless of Mr. Harrell's responsibility in this case. So she's not going to take the blame for him in this case. If he wants a trial date, that's his position.
Let's set it for trial then.
Okay. Now I'll just file a motion too, whatever date we said. I want to get Mr. Hurt and Miss Johnson available too. We'll just try both of them. I don't want to separate them.
Let's look at the 21st of June.
Give me time to get her involved, Mr. Hurt involved.
Okay.
I'm hurt.
Or do you want to just set it for a pretrial in May so we can get them both set?
We'll just set them today.
Okay.
I'm sure it'll be available.
Judge, I've got trials in Casey Circuit.
Okay.
File a motion, set a trial date and set it for May the 12th.
Let's see here. What about June 7th and 8th? I don't have it on here. Well, I put that in the wrong place somewhere. Glad you caught that.
Judge, do you have anything the week of July the 5th through the 8th?
Wait a second. Okay, excuse me, go ahead. What did you say?
Is there anything available the week?
I can't do it that week.
Okay.
Well, we might be able, is this you think it's a 1-day trial?
Probably.
Even with 2 defendants, we should be able to finish it in a day. There's not many witnesses in the case.
Probably, yeah.
Let's take a look at July 6th.
That's fine with me.
Is that a district court day here? Wednesday?
Typically it wouldn't be, but with the 4th being on Monday, I'm not sure.
But we can accommodate it. Both Harold and Johnson will be that day, okay. That was the 6th. The 6th. Okay, you got it.
You got it, 6.
Thank y'all. John Luttrell. John Luttrell. Commonwealth versus John Luttrell. 21 CR 00126. Are you John Luttrell?
Yes, sir.
Here they fear arraignment. Have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with trafficking and controlled substance 1st degree. Are the last 4 digits of your social security number 5446?
Yes, sir.
And your year of birth 1970. Okay, Mr. Sheffield, I want you to acknowledge the identity of your client. The indictment's being sent back to you.
Your Honor, I'm pretty certain this is a direct presentment, but I will accept appointment.
Yeah.
Yeah, this was a direct presentment to the grand jury.
Okay, I'll appoint you to case.
But I would,
Mr. Luttrell, have you filled out an affidavit of indigency? Do you have money to hire a lawyer?
So, no,
Okay, well, we'll make sure he gets an affidavit signed there, and I'll reserve whether I'm going to charge you. And your attorney's been giving your discovery back there that what the Commonwealth has evidence against you to help work on the case. You'll be back here for negotiation on May the 6th, and on May the 12th, your next court date.
Judge, what's his bond set at?
Ms. Pretrial Janessa, what is his bond set?
$25,000 property bond.
Yeah, pretty reasonable. You don't have anybody that can make the bond for you? Sir?
sir.
Do you
Good
have-
try.
Okay, well, all they gotta do is have 25,000 cleared property. They don't have to come up with any big money or anything, so I think that's a pretty reasonable bond. So why don't you try to work on that? If you have any problems with it, talk to your attorney about it, okay?
Yes, sir.
Okay. Rodney Mannis. Rodney Mannis. Commonwealth versus Rodney Mannis. 22 CR 0007 and 21 CR 0020. Mr. Mannis, you're here with the purpose of sentencing. Do you understand that? Have you had an opportunity to review the pre-sentence investigation work done by probation and parole?
Yeah, I see that.
Is it substantially correct?
What now?
Is it substantially correct? Is there anything in there that needs to be changed?
I don't guess.
Okay. Well, I wouldn't know. It's up to you.
There's no substantive corrections necessary,
Any
Judge.
reason why this gentleman should not be sentenced? Want to
No,
plead
Your Honor.
guilty to theft by unlawful taking over $10,000 in 21 CR 0020. Finish or receive a sentence of 10 years, probated 5 years, or until restitution is paid in full. Probation is to be supervised. Defendant shall be released at final sentencing. Defendant agrees to pay restitution amount of $21,160 severally with Josh Davis, 21 CR 0040, and Eddie Dalton through the Clinton Circuit Clerk's Office. Restitution to be paid $150 a month, first to 30 days after final sentencing. Defendant shall pay court costs in amount of
$155.
$155, and I'll let you pay that first payment 30 days after you get out, $30 a month till it's paid. About the other case, the 22 CR 007, I don't see it mentioned in the plea. Mr. Stockton?
It's a companion case. They went back and indicted and changed, raised the charge. I would.
22 CR 0020 is a superseding indictment. What you're saying.
Correct. Yeah.
That's correct. That's correct.
In essence, then 21 CR 0020 will be dismissed as included in subsequent indictment, correct?
That's correct, Your Honor.
Okay, well, thank you very much. And we'll schedule sentencing for the 14th. I mean, this is the sentencing, but so
This is a sentencing.
released today is what I'm trying to get.
Okay.
Is that right?
That's correct, Judge.
Okay, well, then you'll need to meet with a probation and parole officer, officer.
We can meet at the consul office Monday, 4/18.
Okay, Monday, April the 18th.
Your Honor, he won't be released and he is a holder for Tennessee.
Okay,
We'll make it.
they'll come meet with you at the jail to go over the probation situation with you. What kind of holder from Tennessee you have on you?
Well, the charge, he's a misdemeanor charges. They should be here maybe Tuesday to pick him up.
Okay, well, I'll tell probation parole, here's you, they'll try to get you over and get you set up before you go down to the Orange State, okay? Okay.
Yeah.
Thank you very much. Who is next here? Who's next? I'll go to that. Well, I messed the list up. I did. Yeah, okay, see that, mark that out. Okay. Okay, I've got to go down and wait on the grand jury just for a second. I'll be right back up. Won't take me just a second. Oh.
Does it need to be, or? I can tell you the real word. Yeah, well, it doesn't work. Reputation. Judge, you heard that you were closing your office. Asked me if I heard anything. I was like, no, but I know she's gonna be there tomorrow. So I'll ask her. Yeah. Somebody else. And then. We thought you were leaving this. No. It'll come tomorrow. We got a ball game tonight. We better be here. Yes. You'll have to keep it. Okay. Keep it. I'll even get a house signature. All right. My little boy has his first T-ball game tonight, but I had to miss it to go to the middle school ball game in Russell County. So. We'll have to divide and conquer tonight. You saw ball game. That's how we are. My oldest, she plays Little League. This will be her last year, Little League, and for middle school. And then my middle, she also plays Little League. They're on the same team. She plays for a travel team in Russell. And then my youngest is playing T-ball. So we're not gonna have time. You're short at first. Yes, well, that's what I said. I told him, I said, I'm actually considered your sister wife at this point. I said, I need help. It's my husband coaches Little League. So he can't, so I have to do all the travel away. That's what my oldest, she's in seventh grade. She didn't play league last year, but she's busy with middle school ball, and she graded it, and this is her last year. So she's played it. I was telling Justin how we have a bunch of middle school names at the same time. Those little ones are right next to each other, and they get how long. They were constantly. We're on the middle field. Yeah. T-ball's here, baseball plays over here. We had a game. We stayed on. It was last week, last Friday night. And they were practicing. They were kicking foul balls on the little kids the whole time. It scared me. My little one played last year, but we were lucky if we made a good game and he stayed on the field. We're not parking.
Took the whole outfit.
Yeah. They're usually distracted.
Yeah, took the whole outfit. So, I played softball for 7 years.
I never played, I didn't know anything about it, and that's all we do. I don't know, my husband didn't play baseball either. That was the sport they did.
I played college basketball, I played scholarship football. Played gas.
My husband plays here. My middle one, she likes it a lot, but she's gonna be really fun to watch. You don't know how much of career she'll have.
That works out for me. I had got 6th grade. About 2 years, turn.
We hope she'll get one.
I never know where that worked out.
She and her brother are fine. My oldest one, she's about that big around, but she's as tall as me already. She's gonna be tall. Yes, that's her. She could gain weight. Fortunately.
Are we Timothy Perigin? Timothy Perigin, Clinton County Jail.
You probably need to be ready on him anyway.
Yeah.
Timothy Parrish.
Yes, sir. I took her away.
Commonwealth versus Timothy Perigin, 17 CR 0033, 17 CR 00442. Are you Timothy Perigin?
Sir. Yes, sir.
Born in 1970.
Yes, sir.
Last 4 digits of your social security number are 7334.
Yeah. Yes, sir.
If you're on a probation revocation, what do you have, Mr. Commonwealth Attorney?
Your Honor, he's got a 3-year sentence on possession. He's went to drug court. I don't know if he graduated or not. I can't remember.
No, I didn't, sir. I didn't. Yeah.
Yeah, and now he's on, and he's had some recent drug tests where he's tested positive for meth.
Yeah.
So I don't know what else to do with him.
Mr.
I was
Sheffield,
about to skip IOP. I mean, I'm sorry. I
Mr.
mean,
Sheffield,
do what?
Mr. Sheffield, are you on, are you back on?
Sorry,
No.
Judge. Your Honor, we acknowledge the recent drug screens the Commonwealth mentioned. Tim has made strides at times, maybe more so than some thought that he would or thought possible. I'd ask the court consider a sanction and then a release with a treatment option, whether it be SAP IOP or some other option.
I'm willing to do IOP again. I mean, she told me that she would take me right back in, I was just like 2 classes away from finishing that, and I was doing good. I'm so sorry about all the trouble I've caused y'all. I mean, I'm an addict, and I'm relapse. I mean, but now I'm done with it. I'm done. I promise you I am. Done.
Are you working or drawing disability?
Y'all disability, but I'd be willing to do community service. I mean, if that would help, help out with anything. I'm willing to do anything.
Well, I think the government's just perpetuating your drug habit because my grandma always said idle hands is the devil's workshop, and she's a pretty smart lady.
That's true. But I did work a long time in concrete. I mean, I just got hurt, and
I know it, but there's things you could do.
do what?
I said there's things you could do.
What do you
I know, yeah, and I did work.
Okay, wait. We could all talk about things we could do. When I used to do disability cases, I lose my cases sometimes, and my people could work at a toll booth. Anyway, hell, there wasn't no toll booths around here. In any event, what do you suggest, Mr. Stockton?
Well, I like Mr. Perdue, but I don't think unless he's got something to do, he's going to have relapses. That's the problem I can see. And I like him. I ain't saying this out of disrespect.
Yeah, I know that.
I think if he had something to do and he kept himself busy, he could probably beat this. But if he's not, I don't know that he will.
Well, how about if I do the IOP and do some other, like go my GED and stuff, finish that? I mean,
maybe you could go to voc rehab or something and see if there's something you could do.
And what now?
There's a program called vocational rehab to see if there's things you could do.
Yeah, I mean, I just right now my family's going through a hard time, and I need to be with her. And it's really trying to.
Let me tell you. Can you afford an ankle monitor if I put you on an ankle?
Yes,
monitor?
sir. I can. Yes, sir.
Okay.
I can.
What I'm going to do is how many days you been in?
32 days today. Sir.
I'm going to make that your sanction. Your 32 days. They won't count good toward your time. Be your sanction. And then I'm going to put you on an ankle monitor so somebody can know where you are.
Okay.
Subject you to random drug tests, require you to meet with a clinician and follow all of their recommendations, including the clinician should work to find you vocational rehab things to see if there's anything you can do. Okay. Okay. Now, I think your mother's, this your son? Your mother's here and she's watching. And if your family needs you, I mean, they're gonna need you more in the next few years than they ever will, probably.
Yeah.
So just don't let us down, or there won't be no more. Well, I know you're well intended, but everybody promises me they're gonna do something. You understand? I mean, if it was addiction, it'd be easy to walk off it. With Miss Parrish, you're in pretty good shape. You just need to be quiet from here on out and just say,
yes, sir.
You cheated death again, okay?
Yes, sir. Thank you.
Okay. Well, thank you very much. Would somebody need to tender an order to include that, to get him out and get him to the clinician? Okay?
I think we're working on it, John.
Okay. Ricky Phillips.
Yes, with those conditions.
Good luck to you, man. Ricky Phillips.
Yes, sir.
Are you Ricky Phillips?
Yes, sir.
20 CR 0019. We're here for a pretrial conference. You born in 1985, Mr. Phillips?
Yes, sir.
And last 4 digits, social security number 3824.
Yes, sir.
Okay. What do you have, Mr. Stockton?
Well, he needs an attorney and he needs to be on May the 12th and May the 6th for negotiation. Because Miss Jones said she'd no longer be representing his email I got yesterday.
Was she our lawyer from Macquarie County?
She was. She's got some issues. She's going to be off for a while.
The road was long down here too. Well, Mr. Sheffield, are y'all gonna have to get him conflict counsel?
Yes. I represented a co-defendant in the case that's already resolved his case. This would have been my Joe Daley, would it not, Jesse?
That's correct.
Yeah.
Yeah.
Well, now that case is resolved, do you still have a conflict, you believe?
I think so, because it's
Okay,
very possible.
You don't have to tell me why. Well, we'll have a conflict of counsel. Here's Mr. Hurt walking in here now. He does some conflict counsel work. How y'all do those assignments?
We beg and plead.
No, I just want you to take his case here. Well, I'll make your next court date.
You make it after May 17th, I'll take the case.
This gentleman needs a lawyer, needs somebody to talk to him.
I'm happy to talk to him.
Okay, let's have you here. May the 12th, we have a negotiation date. I'll get you in first, in and out.
Okay.
Okay. You want a negotiation day on the 6th and on the 12th, and since I think Commonwealth attorney will agree to take you first on that day. We both know what it's like 2 weeks before election, don't you, Mr. Stockton? So you got to have your microphone on there, Mr. Stockton, unless that.
I'll get him out quick, Your Honor.
Okay. Your new lawyer will be over to talk to you, sir. Ricky Phillips. And the case number is 20 CR 0009 19 00019. Misspoke. 19. Yeah. Okay. Michael Richie.
Richie.
Commonwealth versus Michael Richie, 22 CR 0015. You're here today for the purpose of arraignment. Are you Michael Richie? You Michael Richie?
Arraignment, is it?
Are you Michael Richie?
Yes.
Okay, you have to say something because your voice acts. You have a right to remain silent. Are you represented by an attorney?
Yes.
Okay, Mr. Sheffield, is this one of yours?
Yes, Your Honor.
The grand jury of Clinton County's returned an indictment charging you with wanton endangerment in the first degree. Do you understand that charge? Mr. Sheffield, the indictment is on the way back to you. Acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Okay, we got we got the appearances on the 6th and 12th. 6th for negotiation and the 12th for next court appearance. If you make your bond, both of them are conditions of your bond. What is this gentleman's bond? Ms. Pre-Paul Jeanette?
It's 10,000 cash with an ankle monitor.
And why is that?
He's a moderate risk, and that's what it was in district court.
Okay.
Judge, I believe he can make a 10% bond, and he's hopeful.
This is not a 10% bond, was it? 10,000.
It's not, but he could make a 10% bond, and he's hopeful that he could get his job back at Tyson, as apparently he's a very good worker, and they're interested in having his services again.
How do you feel about that, Mr. Stockton? Is it okay?
I'm fine as long as there's no contact with the victim in this case, so we can have a negotiation.
Okay, that'll be one of the conditions, no contact with the victim, and you can go to church, work, hospital, or to meet with your attorney, okay?
Does he have a place to live here if he's not living with the victim?
See, I don't know. She's gone back. She has gone back and either dropped or asked for the EPO DVO to be amended to allow.
Well, this is not a case I'm worried about the victim because I've got a video. So I want to make sure he has no contact with the victim and has a place to live.
Okay, I can call Dad and have Dad come get him.
What's your father's name? I can't hear you, man.
Maybe we need to do an agreed order with him, an address, who he's going to be living with, and, you know, make sure he's still got a job. And I'll be glad to sign an agreed order to reduce his bond. But I need that information.
Mr. Richie, who are you going to live with?
Well, if I can't go to my wife, I would have to go back home and Hazard.
Well, you can't live in Hazard and work here at the chicken plant.
Yeah. So this is what happens. We get these bond things on this court day and everything just wants to fly through, and you've got to think about these things.
Yeah.
I try to think about some things on occasion.
Well, I ain't saying you, but I'm just saying what the defense tries to do.
I know we all do, you know, but
I know.
You know, he says he's gonna go home. That's just like when Mama's surgery was. I don't know when Mama's surgery was, you know what I'm saying? Don't know where home is. Okay. Can you find a place here in Clinton County to live except with your wife who you got to stay away from?
I doubt it.
Okay, well then
there's a couple guys getting out here. I might can check with one of these guys.
Well, when you find a place to stay that's to the acceptance of the Commonwealth attorney, they can sign an agreed order, and I'll let you out and let you get back to work. Okay.
Okay. All right. Thank you.
Thank you. Paul Richie. Paul Richie.
Just take facility off rehab.
Paul Richie. Commonwealth versus Paul Richie. Are you Paul Richie?
Yes.
Okay, this is 22 CR 0003. Were you born in 1982, sir?
Yes.
Last four digits, Social Security 7903.
7903, yeah.
Yeah, we're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Okay, is it substantially correct, counselor? Is there any reason you shouldn't be sentenced?
No, Your Honor.
On a plea of traffic control substance first degree Class C felony, defendant shall receive a sentence of 5 years, remain incarcerated until final sentencing, and the balance probated for 5 years shall be referred to the social service clinician, follow all recommendations. Court costs in the case, how much? $155, and you'll probably need some time to pay that. I'll let you make your first payment 30 days from day of $30 and $30 every month after that till it's paid. And I don't guess there's any reason why he can't be released today then, is that correct?
Yes.
Right. You need to meet with a probation and parole officer. When you want him to meet with you? What day of the week is April 19th?
Next Tuesday.
Okay, go to the probation and parole office next Tuesday to meet with your probation and parole officer, and stay away from any drugs or anything. Don't go over there and just get gommed up right at first. You hear what I'm saying?
Yes,
and
yes, sir.
Work with your probation and parole officer. Maybe you make it through this thing. Okay.
Okay.
Okay. Good luck to you, David Ray.
Thank you.
David Ray. He's got two more over there. Commonwealth versus David Ray, 22 CR 0011. Mr. Ray, I'd say good morning or afternoon. Well, it's barely good morning. I can say for 3 more minutes.
Morning.
Yeah. This is, you're here today for the purpose of an arraignment. Were you born in 1975, sir?
Yes, sir.
Okay, and the last 4 digits of your social security number is 7615.
Yes, sir.
Are you representing Mr. Sheffield? Is this your client?
Yes, Your Honor.
Grand jury of Clinton County is returning an indictment charging you with possession of methamphetamine, promoting contraband, and being a persistent felony offender. Okay. Mr. Sheffield, you acknowledge the identity of your client. The receipt of the indictments on the way back to you. Reserve all pretrial motions. Enter plea of not guilty.
Yes, Your Honor.
Okay. Okay, we'll have on the 6th of next month, you'll be here for negotiation, and the 12th, you'll be here for your next court date. Both of them are conditions of your bond. What is this gentleman's bond? Miss Pretrial, pardon?
The $25,000 surety, but he also has a district court case and waived the grand jury that's holding him.
That went to the grand jury today. I think they returned an indictment on another possession case.
We'll just wait and see what happens on that, and we'll maybe at the negotiation day, Mr. Ray, they can write both of your cases up today and try to resolve them. Probably save you days in the long run, if you know what I'm saying. So, okay, thank you very much.
Thank you.
Okay, now, I think we still have Sherman Hensley.
Hensley.
Sherman Hensley.
I need the paperwork.
And Travis Flowers and who else? I don't see Richard face. No. He's here, so, okay. Sherman Hensley.
Yes, sir.
Commonwealth versus Sherman Hensley, 21 CR 0027. You are Sherman Hensley. Is that correct? Sherman?
Yes, sir.
You
Yes,
have
sir.
two cases, 21 CR 0027 and 21 CR 0038. Pretrial conference on 27 and a motion. Well, actually, had a motion to determine competency hearings there. Where are we at on these things?
Your Honor, Mr. Hensley has been evaluated, and there is a report that was provided by KCPC.
Okay, do you have a copy of it?
I do, Your Honor.
He was found competent, Your Honor.
That's correct.
Well, what do y'all need to, now that he's been found competent, you want a negotiation day?
Well, if he'll stipulate competency, we have a felony plea.
Okay. Will you stipulate competency after the report?
It would be my understanding, Your Honor, that my client would be willing to do that, yes.
Okay.
He's
satisfied with the report. Where is it a felony plea?
Yes, Your Honor.
Okay, let's go back and do that. Mr. Hensley, you were born in 1973, is that correct?
Yes, Your Honor.
And last four digits of your social security number is 8692.
Yes, sir.
Okay, a motion's been tendered, says that you wish to enter plea, which you've acknowledged. Are you under the influence of drugs or alcohol now?
No, sir.
Okay, is this plea voluntary and freely given?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney? Are you satisfied with his advice?
Yes, Your Honor.
Feel like you're fully informed about your case?
Yes, sir.
You don't have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I need to go over those at the end of them. I'll ask if you understand them. You have the right to a trial by jury. You have a right to have people to cross-examine people who testify. You cannot be compelled to testify against yourself. You have a right to confront and cross-examine all witnesses that anyone called to testify against you. Right to produce evidence. The right to call witnesses and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. And a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges. By entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, I will tell you that I am rejecting it. You can withdraw your your plea then and have a jury trial if you desire. Do you understand that?
Yes, sir.
Okay, Mr. Stockton, will you go over the recommendation of the Commonwealth, please?
Yes, Your Honor, in 21 CR 38, he would plead guilty to trafficking and controlled substance first degree, receive a sentence of 10 years. 21 CR 27, he would plead guilty to possession of controlled substance first degree, receive a sentence of 3 years. He would get credit for time served. He's been in jail a long time, but he would, and after he served 60 days after sentencing, I would be agreeable to shock him into the specialty court program if he qualifies. And he would pay, he'd have get credit for time served, pay costs discretion of court, and all evidence in these two cases would be destroyed.
How long has he been incarcerated? How long have you been incarcerated, Mr. Hensley? Mr. Hensley, how long have you been incarcerated?
Around 8 months total.
Okay, well, what I'm going to do is waive the court costs because you've been incarcerated that much, and we'll have a sentencing for you on May the 12th, and you say that he'll get out on the 12th, then, Mr. Stockton?
No, he's going to be assessed for drug court.
Okay.
And once he's eligible and they're ready to orient him, I'll shock him out in drug court if that's all right with the court.
That's fine. That's fine. We'll make sure that we get the referral signed. We might have done it yesterday, did we?
I think we submitted it today.
Okay, well, we'll sign the referral, and Mr. Hensley, when they get closer, and then they'll have to orient, and it shouldn't be too much longer after your sentencing date that you get in. You won't get on that. So the end is near, man. If you can just hang in there, okay?
Yes, sir.
Thank you, Your Honor.
Thank you.
That's all I had, Your Honor, if I could be excused.
Yeah, that's good. We had Travis Flowers. Is he still over there? Travis Flowers, and then was there one more over there at the jail? Travis Flowers.
Yes, sir.
This is Travis Flowers, 22 CR 0010. Mr. Flowers, were you born in 1993?
Yes, sir.
That's 4 digits of your social security number, 5823.
Yes, sir.
Purpose of arraignment, you have the right to remain silent. Mr. Shepard, is this one of your clients?
Yes, Judge.
Okay. Mr. Flowers, a grand jury Clinton County is returning an indictment charging you possession of controlled substance of first degree methamphetamine, possession of marijuana, possession of drug paraphernalia, carried a concealed deadly weapon by prior deadly weapon offender, trafficking in controlled substance in the first degree, operating a motor vehicle while revoked, being a persistent felony offender. Do you understand those charges? Mr. Do you understand those charges?
Yes, sir.
Okay, Mr. Sheffett, you acknowledge the identity of your client, the receipt of the indictment, waive formal writing and reading of the indictment, enter plea of not guilty, reserving all pretrial motions. Okay, we'll sit in for the 6th and the 12th. 6th for a conversation and 12th for the next court appearance. What are the conditions of his bond?
$50,000 surety with an ankle monitor, and then there's the standard conditions. He's a high risk. I think that's why.
Yeah.
I've had him in NCIC before, Your Honor. He's hard to keep up with. I'd ask for a bond here.
Yeah, well, I'm not going to reduce the bond. $50,000 property, was it?
Surety.
Well, that's okay as long as there's an ankle bracelet on it. So, okay, thank you very much. Is there anybody else at the jail there?
No, Your Honor.
Okay, well, thank y'all for your
Your
cooperation.
Honor,
Yes,
can I speak? My wife, Charlie. Go ahead.
you better talk to your attorney rather than me, because it might be.
What are you wanting to talk about, Travis?
Sorry. On my wife's charges, Ivy.
Don't say anything.
Okay.
That can be dealt with at a later time.
Yeah. That's good advice. You need to follow it.
All right, I'm sorry.
Well, no problem, no problem. I guess when you go to the live docket, we've got a few people that have stayed here with us.
Will be.
I guess we are with Joshua Minton. Mr. Stockton's on the way back out. Joshua Minton says active warrant. You know anything about Joshua Minton? Well, he's on the docket here and he's not here, so I guess there's already an active warrant out for him. William Moore, that seems to be an active warrant out. That's on a diversion revocation, it says here. Ryan Nally appears to be an active warrant out. You had time to catch up with us, Mr. Stockton?
Yeah.
Okay. Neal. Commonwealth versus Neal, 21 CR 00129. Ms. Neal, were you born in 1973?
Yes, sir.
Last four digits, social security number 8417.
Yes, sir.
What do you have, Mr. Sheffield?
Your Honor, Nita here, settlement conference and also met with me. I'm going to meet with her again. I wasn't using the right program when we were reviewing her discovery and things that need to be able to see that we didn't see that.
You want to go to the 6th again on this one, Mr. Stockton? 6th to 14th. You'll be here for negotiation on the 6th. 6th and the 14th, both of them are bond conditions. You understand that? Okay.
This is what, May 12th.
I meant the 12th. I said 6th and the 12th. Jerry Paris. Commonwealth versus Jerry Paris, 20 CR 00053. Are you Jerry Paris? Born in 1979, last four digits, social security number 3738. What do we have here?
John, we had tendered a different order. An extra copy here. The Commonwealth is agreeing to withdraw their motion for vote probation. And Mr. Paris is going to attend rehab program for house in Louisville.
Is that correct, Mr. Stockton?
That's correct.
Okay, you want to submit it here? Okay. Now, if there is additional violations, I'm not going to be limited to going back on these things and include them in my consideration, even though we have an agreed order now. You understand what I'm saying?
Yes, sir.
You understand, Mr. Stockton?
I agree, and I told Ms. Holly, Mr. Paris, when you step out this time.
Okay. Okay, well, Mr. Paris, good luck to you. Hope you turn it around. Are you going to be back with us again, or is this it for you? When you going?
So I will be, I'll be here, you mean today, Your Honor?
Well, no, I know you're going to be here today. You're here.
I'll be here till July.
July. Well, you know, it's a tradition when people leave the practice in this circuit for them to throw the rest of the attorneys a big party and all the staff. So we'll be waiting. I guess you can check with Mr. Stockton to see what preferences we have as to the location. Okay. Patty Poor. Now it says here there's an active warrant out for Miss Poor. Where you been, Miss Poor? Do what? Yeah, can you spell that? I knew you could. I just wanted to hear it again, right? There's that little song. MISSISSIPPI. That's what I had to do when to learn how to spell it. When I was in grade school, I would never be able to spell it out there. Okay, the warrants have been served. She's proved her competence by being able to spell Mississippi, so we've made some progress. You're here today for the purpose of arraignment. They say over here. Yeah, we need to make sure they get them off, or arrest her somewhere. I don't see copies of it. Here are the copies of the indictment here. Okay, who represents you? Direct submission. Can you afford an attorney? Okay, well, we need to get you to do an affidavit. I'm gonna appoint Office of Public Advocacy. Mr. Let's see here, who signed this? Mr. Shuffett, the grand jury has returned an indictment against Patty for charging with trafficking in a controlled substance. And that is in 132, and 133 is trafficking in controlled substance, first degree, 2 counts. You be back here on the 6th and the 12th, is that what it is? And the Commonwealth's giving your attorney some evidence they have against you so he can meet with you and prepare for your defense. I guess your bond will prohibit you, will limit your travels and things like that. So make sure you look at the condition of your bond and follow it, okay? Yeah, what you need to do is you're under a curfew. You're under a curfew just to stay at home, except to go to church, work, the doctor, and you can call pretrial if you need to go to the grocery or whatever, you get their number, okay? So we do that to keep you till we can find out what's going on. And I will make a note that you say that you were wrongfully accused. So, okay, Chad Scott's next. Commonwealth versus Chad Scott, 21 CR 0068. Mr. Shuffett? Okay. Well, wait just a second. Let me get him in front of me here. Okay. I thought his attorney wasn't there. I was going to agree. Commonwealth, Kentucky versus Chad Scott, 21 CR 0068. Are you Chad Scott? Were you born in 1983? Last 4 digits, social security number 9601. We're on a pretrial conference. And what would you like? Identify yourself, counselor, and what would you?
James Acton. I work with the Department of Public Advocacy. I'm here as conference counsel for Mr. Scott.
Okay.
And we were going to be making or filing a notice of election under KRS 446.110 to be prosecuted under the amended statute. Currently, at least and under the discovery I have, the only amount questioned is $717. The statute was recently amended to be $1,000 or more to be a felony. Everything else under that, 500 to 1,000 is a misdemeanor. We're going to be elected go under the amended law. KRS.
When did they change it?
He was indicted before the law was changed.
Yeah.
But the only evidence I've got in the file, this hadn't been raised with my previous counsel. The only evidence I've got in the file for the barn over was sold to a company through him. Once you file your election, I'd just like to have time to talk to the victim so I can see if he's contesting the amount. Okay. Whether it is $1,000.
Okay, do I need to file a written election?
Okay, come back here for negotiations on May the 6th. And the next court date's the 12th. Both of them are conditions your bond.
You may well do that.
I think I'll probably need some circuit court up in Plastic on May the 6th.
Well, they'll be here all day for negotiations. You can just work out something with Mr. Stockton or maybe an alternate day.
Okay.
Just make sure you keep in contact with your client because both of those days, both of those functions are conditioned with bond, okay?
Okay, so May 6th.
Yeah, and somebody might very well have sold some barnwood, not that your client did, for $700. It might be worth more than that.
That's something I don't know. the answer to.
Yeah, I don't know the answer to that either.
What was it? It was May 6th. 12th.
6 and 12. Robbie Scott. Commonwealth, Kentucky versus Robbie Scott, 21 CR 0069. Are you Robbie Scott?
Yes, sir.
You born in 1980?
Yes, sir.
Last 4 digits of your social security 007. And counselor, I didn't hear you. Good. Okay, welcome. We're here today for a pretrial conference. Have you had an opportunity to do negotiation with the Commonwealth?
Yes, Judge, I attended the last negotiation session. Obviously, he's a co-defendant of the previous Mr. Scott. I don't think of that issue, but we will prepare to set this case for trial, having already negotiated. If Tower Court wants to handle it, given that the other counsel, I did not talk to him.
I want to see if I want to have a misdemeanor case or a felony case.
That's
And
fine.
if it's a misdemeanor case, I'll send it to district court. If not, we'll get trial.
Okay, well, we'll set this the same, the 6th for negotiation and the 12th for a trial. And the Commonwealth will get you that information at least at the negotiation date.
Judge, I'll be out of town on the 6th, but I'm going to try and get in touch with Mr. Stark about that.
Well, okay, make sure you keep in contact with your client so he'll be available and you'll have authority, okay?
Thank you, Judge.
Okay.
The 6th was the negotiation, what was the other day?
12th. Yeah, anytime you're here as conflict counsel, we're going down through that. It's the only case you got. You just make sure that you come up and bring it to the clerk's attention or my staff lawyer, so you won't have to sit here all day, okay?
That's okay, Judge. I know you have a long time.
Well, that's okay.
Thank you, Judge.
Okay. Shannon Smith. Shannon Smith. Commonwealth versus Shannon Smith, 21 CR 003. Are you Shannon Smith?
Yes, sir. I am.
You born in 1971?
Yes, sir.
Last 4 digits of your social security number are 3911.
Yes, sir.
We're here for a pretrial conference. Mr. Stockton, what do you have?
Your Honor, I'm going to leave dismiss this case, and once he pays court costs, whatever you assess in this case, this case was handled in Tennessee. I spoke with the prosecutor down there. There's no restitution owed up here or anything. I think it's satisfaction.
Well, you're gonna dismiss it?
I will. I just think.
Well, I don't think I can charge him court costs if you dismiss it,
Whatever you want to do, that's fine.
unless you want to volunteer to pay court costs. We need it up here in
I
Kentucky.
know, Mr. Smith, that's what they routinely do in Tennessee. They'll dismiss the case, make court.
Yeah.
Let him go outside. That's all you want to do. Yeah, I'll make it get back to work.
Well, you can, you buy diesel?
Sir?
You buy a lot of diesel?
Yes, sir.
Well, that court cost won't buy you much diesel. Okay, well, you want me to hold off, Mr. Stockton, or you ready to dismiss it now? Mr. Stockton, you
Yes.
dismiss it now?
Yes.
Okay, I didn't know whether there was anything in Tennessee. Okay,
No, there's no restitution.
okay. You can go.
Thank you, sir.
Okay. Michael Stinson. I think Mr. Cross is gonna find him. We don't have to find him. Yeah, I know. Michael Stinson's not answering the call. Bench warrant for Michael Stinson. Okay, now we had Richard Mason. Commonwealth versus Richard Mason, 18 CR 0030 and 22 CR 0006. Now, Mr. Mason, what was your year of birth? 1983 is your year of birth, and the last four digits your social security number. Okay, I'm going to arraign you on the second charge, and looks like,
This was added on today, the arraignment.
yeah, here's the grand jury of Clinton County has returned indictment charging you with theft, unlawful taking, or disposition more than $1,000. You understand that charge? Counselor, do you acknowledge the identity of Mr. Mason or see the indictment, waive formal reading, arraignment, enter plea or not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, sir, you shall come on May the 6th for negotiations and May the 12th for your next court date.
It's on the revocation.
Now, the revocation, Mr. Stockton, would you want to put off the revocation until after the negotiation?
State's prison was brought by private individuals.
Okay. Okay, see you on those 2 days you be here, sir. You just look at me and that for a second. You be here on those 2 days, okay? Part of your condition. No problem. Okay, now we have somebody else back there. Yeah, we thought you were in jail, I guess, right? Come on up. I'll just skip over. Oh. Got no page there. Commonwealth, Kentucky versus Harold 2, 21 CR 00135. Are you Harold 2? Were you born in 1983? Last four digits, social security number is 8187. 81 what? 8178, okay. Please, everybody make a note of that, okay? 8178. Okay, you're here for a pretrial conference. Okay, a motion has been tendered, Mr. Harold Toole. It says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Okay, state your full name. Are you the same person named in indictment number 21 CR 00135? Is your judgment impaired today? No. Do you understand the charges against you that you're in a guilty plea to today? Have you had plenty of time to discuss the evidence with your attorney? Are you satisfied with his advice? Yes. You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. But before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to acquire the Commonwealth prove on a reasonable doubt that you're guilty of charges against you. By entering guilty plea today, you give up all those rights. Now, I may consider Commonwealth's recommendation in this case, but I also may apply any range or sentence provided by law. If I don't accept the recommendation, I'll tell you I'm rejecting. Is this a diversion program? Okay, now I want to ask you a few other questions here. Have you personally been diverted in the past 5 years? Well, you had some, have you ever been diverted before, had a pretrial diversion before?
I think you got a felony.
Okay, has he had any felonies in the past 10 years? Okay, are you on probation or parole currently? Okay, you waive a speedy trial? Yeah. Now you've looked at the written motion for diversion and gone over it with your attorney and looked at the agreement. Is that correct? And that was your signature on the diversion agreement? You understand if you complete the diversion program, the case will be dismissed pretrial diverted. However, if you do not complete the program you brought in front of me, I find that you violated, I will revoke your pretrial diversion, have a pre-sentence investigation report done, sentence you, and you'll be a convicted felon then. That can be used against you in the future. You understand that? Knowing all that, it's still your desire to waive your constitutional rights and enter into this diversion agreement. Okay, Mr. Stockton, did you completely announce the terms of that?
You see, they plead guilty to trafficking and controlled substance first, with less than 2 grams. 5 years, pretrial diversion, 5 years. If they refer to the SSC, follow all recommendations. You'll serve 60 days home incarceration. Receive credit for time served, based on for costs, obtain and maintain gainful employment. And all evidence in this case will be recorded. While he's home incarceration, he's got a job.
You want a bracelet on him?
Yeah.
Okay, so you'll need to get a bracelet put on you by the end of work today. Is that possible? Can y'all get somebody to put a bracelet? Who puts bracelets on, ankle bracelets on? Okay, well, you need to make arrangements, and if he can't get one on you because of any reason he has by 4 o'clock today, you need to tell the sheriff's office about it. You'll need to get one in the morning, okay? And you need to follow the rest of those agreements. Now he needs to date his signature on there, I think. Now you also need to meet with a probation parole officer. He's sitting right there, so you make arrangements for him to see when he wants you to meet with him. Okay. Where do you go? Where do you go visit the children? Okay, whose house? Who? What? Okay, well, I'll allow you to visit at that house without getting permission. Okay. Okay. Carilla Whitehead. Carilla Whitehead. What do you, that was up for review. I can't hear you.
He owed her co-defendant owed about $1,500 restitution. He's got it down to $150. He called my office a week or 2 ago and said he needed some more time. And I said, that's fine. I didn't realize who it was. And then I don't mind passing her case. I don't want to have her arrested on this.
Just put it, send it to June then.
Yeah.
June and that. Okay, is that complete criminal docket? Say yes, just a human. Who are you?
It's at 1.
Got staple against them. Maybe we'll get the crisscross on right there. Well, it started off rough, but it whimpered out all right. Well, hey, listen, I don't know why you let anything get you mad, but when I pulled up there and my people in that parking place out there, and I had 5 minutes to get in and all that stuff to unload and didn't know whether. Yeah. By the time I get over there, guy says, goes down and says, sorry, Jerry. Didn't say anything to him. You know, but There's no way in the world that I would pull in a place that was a restricted park place. I mean, there was an open place there that had sheriff on it. No, I didn't pull in it. You know what I mean? Because it's just got a cascading effect. You know, they pull in mine, I pull in sheriff. Sheriff needs that location.
See, I'm with my car, sheriff's office, I've got the sheriff and the deputy.
Yeah.
So I'm walking in, I put mine in the next car.
Yeah, well, I'm over there in front of the bank, sitting out in the middle of the road. Then I went over there and left my damn briefcase, had to go get it, so, but if that's the only thing happens to me, I kept on thinking, I'm blessed. Blessed, it's the only thing happens to me.
You get hold of this lookout.
Lanny, you leaving? Hey, Lanny, before I forget about it, sometime, ask Joe Howard what the history of that stand-up desk I've got up there in my office to see if it's in your family. So when I get finished with it, if any of them want it, you know, I think it does have some significance. Yeah, well, if y'all not interested, it's fine, but he said it was the master's desk that they used there in the old store to back up. Yeah. If any one, I mean, because it's somebody will get it one of these days, and if your boys, it's kind of interesting piece. I had it fixed up pretty good. So, okay, have a good day. Is Vicky doing any better? Well, she ought to be scared.
There's something bad wrong with her. And she's supposed to have Texas see a specialist.
I was sending her to Mayo Clinic or somewhere and find out what the hell's wrong.
She told me about it. I told her that's what
If they'll send her to Mayo Clinic, is her not to worry about the travel up there. I'll cover plane fare, whatever, you know what I mean? Because I mean, there ain't no lazy bone in her. She's worked her whole life, you know.
right now, I feel she's got everything that's going on. Income taxes.
Well, you know, in some ways, her life is better now than it's ever been. You know what I mean?
She'll do good this new job.
Oh, yeah, hell, yeah. It's just right her thing.
Thank you.
Yeah, see. Let me yell at, come back. Oh. I'm always afraid to stand up, afraid I have to immediately go pee somewhere.
Thank you for having us out. No, thank you for having us.
I laid him in front of him. I don't know what he did.
I understand. They're just here.
I don't know if they're signed there or not, but I did lay him in front of him. To check it out. Okay.
Listen, did you see the agreed order on Joseph Wallace? Did it come through?
I laid the whole stuff. He may have taken them back there with him.
Perhaps he did.
I laid the whole stack.
Okay.
Thank you. Yeah.
Listen. Not yet, this is the first time, so I was terrible. Let's just not sure. Now, it's like Tuesday.
I put it around at 1:30. Probably started getting MRI done for Dr. Right back just as soon as they to me. It's been bothering me for about a month with softball. They made us get an X-ray before insurance would approve an MRI, even though we knew it was nothing bone related.
Which is better?
Honestly.
Well, that first time I tried to send an email, kicked it back, saying it could be delivered, and I was like, that go back.
Yeah, I got two of them, so
Oh,
it must
did
have
they?
eventually sent it through, and I wondered, another one popped up, I thought maybe it had to make it the same email.
I called them, I said, no, we ain't here yet. I said, your website says it's there.
Do you want my cell phone? That's the easiest way to just shoot you a text if you need something.
Well, it's like I told Jesse, hopefully we'll have y'all somebody here. I'm hoping by 16th.
Yeah. Maybe. I'm
We
just saying.
we sent a name up. And say, just, you know, that's even if that person would, you know, accept it or whatever. We've had, it's not been many, but we've had a few that we've sent up, and then next thing you know, call them, let them know, and they're not taking it, so.
Can't blame my little brother.
They did just raise their all of them up to grade 14, so
Well, that's
that's
good.
better than it was.
Yeah. Yeah,
I tell you though, when I saw that article come out or whatever, and they said for the social workers, because originally whichever one it was, I don't remember what it was, they had 26,000. Is what they were gonna give him in a raise. I went and told David, I said, I walked right to his office, I said, I'm gonna give you my 2 weeks notice. He said, what? I said, I'm gonna go be a social worker. He said, I said, this thing here says they're gonna give him $26,000 extra a year. He said, what? Of course, it's 2,600.
Yeah.
I was like, hey, what, 26?
My brother and my dad both worked down at the Lake Cumberland Youth Development Center. They didn't think they were gonna get the raise at first. They weren't included in it, but now they came back and included it in it.
Well, we was talking about, like, I don't know. I know AOC is their own beast of things and stuff, but the Commonwealth parents and stuff, I don't know.
Yeah, I don't know, because they're under the executive branch.
Well, it said all executive, but I thought somebody said the other day that attorneys, like DPA, I think.
I don't know, we got it, I know we got it.
But I know he vetoed the legislative side. I think we'll vote to veto his veto.
Oh, yeah, absolutely.
No, I think everybody.
I agree.
See you.
just feel like my head's spinning. I don't know what I've done, what I haven't done. I try so hard to get everything done during the board, and I can't. So, he's flying today. Yeah. I'm just so happy all the jails cooperate.
It's got some validity to it. But it's there. I think he's heading to Stanford for a.
I'm good.
So it's like their big retirement. I think it's just.
Okay, I hear you say I was talking. There was some paperwork. Personal, I said, it's DEA, immigration, all the paperwork all the time.
But.
Last month. It was so smooth. Yes, it was amazing. It changed.
I wish, maybe you could take Susan. But, it's the work you gotta do to get.
Yeah, yeah. I think you can do it.
Yeah, but she really. If you're gonna wing it, sorry, you gotta be sure to go. I think Brad Carter, he just said that. I don't agree. That's all. I'd probably use it 3 days long. If she had money, she'd be paying it. Yeah. Get it done. Get it over with, yeah. $33. Yeah. Would it never get to buy raffles? Said for a long time. Been about half an hour in county attorney's office. Instead of like spending over Big county attorney, you can get a assignment or something. That's what, man, whatever you're supposed to have on. The honorable, she's still around against all. Next time I see you, the sweater, the jacket. He rode over with me. No, that's just a normal look. He finally got his haircut a couple weeks ago. I never met the guy. He got had been very nice, very Dan Brown, who should be, he's the one who had the little confrontation. All right. Next, starting quarterback session, Thank you, Beatty.
So we have the child support docket. Child support docket. Cabinet versus Mary Adams.
She's out there, this is a count. Order to pay $275 a month. Current 84 in arrears, less than 1,000 be paid out before the name of that.
Cabinet versus Chad Scott.
Judge, we have to reorder.
Cabinet versus Silva.
This is a out of state case, exempt motion. That paid $200 for May 16th.
Okay. Cabinet versus Hall.
We'll pass that.
Generally. Okay. Cabinet versus Hutcherson.
She's out there.
Cabinet versus Hutcherson. What do you have here?
Your Honor, to give a little background, this, we filed a contempt motion on 12/13, December 13th, the court decreased the contempt amount from 700 to 500. With that due by 1/12/22, and there were no payments received. And then on the 13th, we were back, and the court ordered her to get a judge for a wage assignment to be put in place by February the 10th. And so far, to our knowledge, there's no job, not been able to do a wage assignment. And then also know that she was arrested on some trafficking charges on extradition circuit court. Was at this time, nothing's been complied with, it's been ordered by the court.
You want to move over here and let her behind the speaker?
Yes, absolutely.
You raise your right hand, please, for the testimony you've got to give us truth, the whole truth, nothing but the truth. You want to inquire of her?
Yes. Ms. Hutcherson, have you been able to get a job?
No,
Have any applications in?
no, I don't, I haven't had any transportation anywhere.
You have travel, kitchen transportation. Question about the very long, have you been charged with guidance since you were before last? Have you been here criminal charges? When do you think we might be able to get a job?
That's not good enough. As soon as possible.
I have provisional.
You need to get a mask on, sir. Need to get a mask. Go over here and give him the mask.
I would start today, I guess, when I'm driving around.
Why haven't you been looking before? You've been under this order. Wait just a second. You've been under this order for all this time, and then you come out here and you say you might be start looking for it today. Why shouldn't I send you to jail today? Give me one good reason.
Well, I was taking drugs, I'm gonna be honest with you. I got put in jail. I got out of jail. I'm trying to get my life back on track.
Okay, when we finish here today, I want you to go down there and work something legitimate out. You're gonna have to get a job and get some structure. You guys need to put masks on. You're gonna have to get some structure to your life. Now, how far along are you in your criminal case? You just had a hearing today or something? So you don't know how that's gonna end up, you know. But if it does end up with drug court or whatever it ends up with, have you ever been to drug court before? Well, if you go to drug court, you're gonna have to get a job. How much total arrears does she owe?
You don't have that on this document.
Probably recent motion.
It would be well over 1,000. If I can see the file, we have that.
Well, let me tell you, when we're over here today, I want you to go down there to the county attorney's office. You've got a week from today to find a job. There are people, you can get a job anywhere now. Geez, I mean, people everywhere are hiring. Everywhere hiring.
I've got this with numbers on it that can help with jobs, so.
I guarantee you that you can go to any of these fast food places here in town, to any place else, you know, especially if they've got anybody working there that's had a drug problem themselves in the past, that want to help other people get out of that. You got to get, you're in a death spiral right now. Okay, so you report within a week from today to them of where you're employed so they can get a wage assignment on it, and I'm going to let you stay free. But if you stay like you are with no other source of money or no other source of income, you'll get messed up in some drugs. Exactly what you'll do. You'll do it for money or To live off of or to eat. Okay, well, thank you for being here today. And you got 1 week from today. Okay, y'all create an order on that. Cabinet versus Perigin. Do as low a wage assignment on it as you can. When you can, you know what I mean? Crutchfield.
That's one for the call.
She's here at all. He's not big for it.
I think everyone else out there.
She worked.
Judge Crutchfield have, Crutchfield and Fitzgerald. Yeah, there's.
Wait just a second. It's the same case?
Oh, you thought it was- yeah, yeah, I see.
Tell me what your default judgment is asking.
Judge, Crutchfield, asking this not just so you'll pay, $199 a month in current for the arrears.
Are you Mr. Crutchfield? Pull it up over your nose there. Okay. Now go ahead and explain to Mr. Crutchfield where he is on this thing.
No, she's agreeable to this.
Okay, Mr. Crutchfield, if you need a closer or more detailed explanation of this, if you'll ask these folks here when you can come down there to the county attorney's office. These things pretty much take care of themselves as far as the forms they speak there. Are you working somewhere now? Where's that? Where? Well, they'll do wage assignment from there. That's the best thing you can do is just get a wage assignment and then work all the hours you can, man. Okay? Okay, thank you. Make sure you make an appointment with them, go down, and let them explain this stuff to you. County Attorney's Office, okay? Cabinet versus Fitzgerald.
Judge, I guess, Fitzgerald has voted, so forth, that's the same motion.
You have a big black pen over there. This pen here, I think it must be a gray pen or something that I'm not supposed to be using. Yeah, thank you so much. Every kind of pen I like, the AOC quits buying, you know. Get a better price than terrible pens, right? Are you employed anywhere now? Okay, well, they'll do wage assignments and things. You need to go down there at county attorney's office and let them explain to you how you can get a wage assignment going on and what percentage and that sort of thing, and make sure you're candid with them on how much you're gonna work and what you can pay. Get yourself out from under this thing, okay? Okay, thank you very much. Now we got a 115 DVO docket. Smith versus Smith. You what? Y'all want to come forward? Beat that dealer. Are you Karen Nicole Smith? And are you Jacob Allen Smith? Okay, you want both of you raise your right hands. Swear the testimony about gives the truth, whole truth, nothing but the truth. Okay, now tell me, you want to step back over this way and you get behind the podium. What's the deal here, young lady?
Right before, the incident on the tour, he was calling me threats, trying not to take all the court, they have to make a fine, pay it, more, all the nice threats, sign off on the child support owed. I had done that one with about 2000. Just recently, he did make an agreement with his mom and his sister that he would sign off.
Okay, I'm not, this is not a child support hearing. This is a.
No, that's where the threatening and all that.
Okay, well, I want to go to the
That's
threat.
where the other thing took place.
Okay, tell me what he did exactly.
Like I said, he just called and said that he was going to take a child support, his phone threatened, he come out.
What did he threaten? Tell me what he said when he threatened. Do what?
It's been like a month ago, so I don't remember exactly what was said.
Well, I can't really make any kind of finding if you can't tell me what he said.
I mean, there was, just that he would do whatever he had to do to not pay child support, he has a few kids and all that.
So you're wanting to extend this, is that right? It's already in place, you want to extend
I
it.
mean, yeah, that's what we have to do. Because
We don't have to do anything. You're asking me, I'm asking you what he said and what you want to do.
Yes, that's
So you
what I
felt
would do.
threatened again, he called you a threat, wait, when I'm talking, you need to stop. So he calls you back and he threatened you again. You don't remember what the threat was. He's gonna beat you up, he's gonna come down there and do something to you.
Done it all. I'm gonna beat you up or I'll put brains out. I mean, it's this, that, and the other. It's,
Okay, and when did this happen?
this has been, like I said, it's been probably 6 months ago.
Yeah, that's when you came down here and asked to have this reissued.
Yes.
Is that what? So it's important to find out. It looks a little confusing to me.
It's in place. They
And
had
she
court
wanted to
last-
extend it for how long? She said 6 months, a year, what she said?
Yeah, so they had a court last month and they didn't show up to the issue.
Yeah. Why weren't you here last month?
I actually had forgot that I had 4 days, I was at work.
Okay, you want to stand over here? Okay, you come back here. You're already under oath and tell me what the deal is, sir.
I didn't cuss her up, say nothing else, or else ask about my kids. And I hung the phone all 3 nights. And then I went, that night, I was with somebody and I had a summons on me or whatever, I went still that night, and I had APB on.
And you had what the same day?
I had some kind of summons on there or something. I had to go, no, it's child support. I'm sorry, it's child support. I'm still. Got out that night, but I had EPL on me that same night. I went in jail, got EPL when I was in jail. I ain't seen this girl over a year. I haven't talked to her on the phone or nothing over almost a year. I have no idea why this thing on.
Yeah, why did you call down
I
there?
called down to check on my kids and see if I can see them. And
Now, this is not about visitation, but while you're here, I'm going to ask you about that. Do you have any visitation ordered by the court?
I've got 4 visitations on Saturday and every other Sunday.
And are you exercising that?
I have not seen my kids in over a year.
Yeah.
I've seen them on the go or something, like went to a store or something like that, but I have not, she won't make them or nothing.
Okay, what you need to do is get a lawyer about that and bring it back in front of the court. This is not this. Now, What is the level of the EPO or DBO we have now? Is it just a stay away or what is it?
Just 500 feet. No contact.
Yeah, well, I don't think it's a bad thing for you to stay 500 feet away, so I'm gonna reissue it. But I'm not convinced, really. You can move back over here. I'm sure that he's hostile toward you. I'm pretty sure you're hostile toward him. So y'all don't really need to be talking to each other very much. But when he gets a lawyer and comes back up here, I want you to be thinking about what you need to do to what level of comfort that you're going to have with him visiting the children. Okay. And at some juncture, how old are the children now?
My oldest is 13. She doesn't want to have contact.
Well, I know she doesn't. You think that, wait, I didn't ask you to get on the tirade about it. Okay, I asked you how old the child was.
My oldest is 13, my youngest is 6.
And both of them are his?
Yes.
Okay. Well, are they little boys or little girls? Okay, well, I always give people the opportunity to reset relationships. Y'all are not gonna like each other. That's okay. That's between you and the good Lord, how you feel about each other. But whether your 13-year-old wants to see him or not, I don't know what she's witnessed to see your ex-husband do or her father do. I don't know. I don't know what you said about him in her presence. I don't know what the boyfriend has said about him in her presence, but it's not healthy. It's not healthy for her not to reestablish some relationship with her father. As imperfect as we all are, to try to reestablish something. So if y'all come back to me in a different situation, I'm going to continue the protection you have, because I do believe that you're afraid of him and stuff, but I'm not so sure that your boyfriend or somebody else didn't say something to him when he called down there, doesn't want him to call. I'm not so sure of that one way or the other. So I'm going to reissue it for a year and stay away from it. Now, they've got this program that these people got. Somebody told me the other day, it's an app. We used it the other day where people can contact each other on this app on their phone, and everything, every kind of communication they have is recorded, like they text or email to each other. And that way you don't ever have to talk to each other again. But in that way you can keep record. You don't need to be saying anything to her, period. If we can get you on that app, get an attorney, get you on the app. There are a lot of their attorneys sitting over here that do child custody, things like that. The best possibility we got, y'all not getting into it and somebody getting hurt. Now, somebody get hurt here. Your boyfriend could get hurt. Your boyfriend could hurt him. Anybody can get hurt. It doesn't matter how bad you are. You can get hurt. Somebody can kill you, and then you're dead. And we just need to try to diffuse this. So I'm gonna reissue the thing for a year, and then I want both of you to try to get lawyers and work through this thing. Come back in about the custody thing, because that will diffuse the underlying problem. Yes, sir. What do you want to say?
What about my kids? I've been trying to say it for.
Well, that's why I'm telling you, you got to get a lawyer and come. This is about violence here. Sometimes people would even resent me bringing up the visitation part of it here, because that's not what we're here about. That's just like when we come for child support. It's not about visitation. These are three separate things, but they're all related to each other. I guarantee you. Okay. And if you can, I don't know enough to tell you that you ought to try to keep them from having any visitation. I don't know anything about it, but I do know that you need to get involved in some kind of dialogue or discussion with lawyers or other people to try to straighten this out for the kids in the long run. Hey, is your oldest one a little girl? Well, it's a tough world for a little girl out there right now, you know, and you know, they need everybody they got pulling for them. Okay, thank y'all very much. 1:30. $137. Okay, Scotty Stearns versus Juanita Stearns. Yes.
Your Honor, we've reached a temporary agreement in this case. We would like to set it out.
Well, who else is involved in this case but you?
Mr. Coleman, he is out.
You don't need to treat your fellow lawyers like potty plants, you know.
Well, he told me just to go ahead and let you know that.
Yeah. Mr. Cross, you're gonna have to have a talk with Mr. Hurt if he said something like that. Tell another lawyer, just go ahead and handle that. You're gonna have, as a senior member of the bar here, you got to, well, no, there's Mr. Connor back there. He needs to talk to Coleman Hurt about.
Well, I'm sure that Mr. Hurt put as much confidence in Mr. Hurt as Mr. Connor always has.
Well, you better get him for sure. Mr. Hurt?
Judge.
Okay.
Okay.
Stearns versus Stearns.
Yes.
Okay, y'all got a tentative agreement on this
We
thing?
got a temporary agreement, Judge, we about halfway solved.
Okay, what is the temporary agreement?
They have provided proof to my client of our property issues, say we're going to financial issues, I guess, that are still at large. We're gonna set it out 30 days and exchange proof, so that both parties are aware.
Okay, well, just sit down for sure what you've agreed to.
Sure.
Okay, one or the other of you are subject to getting fired at any time in a case like this. So, and if you can get your clients to sign it, it'd be good too, okay? Thank y'all very much. Haney versus Haney.
Your Honor, I was noticed on this, that there was a DRC hearing last year. I don't represent this hanging anymore, and I thought a motion to.
I don't want to let her out because nobody can get a hold of this hanging, but I guess we've got to let this slide out. I'm very
I understand
sad.
it's a contract of the, she did design.
What's the underlying issue here?
Your Honor, this is at least the third show cause motion we've had. She just won't go by any orders. She lives in Indiana. He tells me since this was filed, and I've read all this stuff, you got the kids, you drove 5 hours, what, 5 hours? You got 5-hour visit after driving 5 hours. This woman doesn't want to pay any attention to you, me, Miss White, or the entire Commonwealth of Kentucky. And I think they send a message. Come to court, spend the title of joint custody with these kids, and it's loss of conscience, complete lack of respect.
Well, I'm gonna let you out of the case after today. Okay, and I'm gonna issue an order for her to be here with the children at the next rule day.
Okay.
To explain herself to me. And then if she wants to try to play this state to state thing, then she can go into court up there and we'll have the two judges talk to anything under the interstate compact.
And I'm going to have law enforcement in Indiana serve her because you can't see.
Well, you can have anybody serve you that you can pay, any kind of process server that you want to ever come down. I don't know whether that order is enforceable or not unless we catch her in Kentucky. Okay, and I'll let you withdraw.
I'll spit it over now. I'll let them ask.
Hockenberry versus Speck. No. Okay. Yeah, that'd be, you represent Hockenberry. Give me a little background here on why you think you're ready for trial.
Well, I can file the motion. That's the trial.
I know you didn't, but why aren't you ready? Why you aren't ready?
Well, Your Honor, at this point, we have, we conducted some depositions.
Yeah.
And then we made a couple of settlement offers. We didn't hear back from the other side on those. We can be ready for trial.
Well, I mean, what's unfinished? So you have,
At this point, we'll have to depose an expert, Your Honor, if we're going to prepare for.
Is this a car wreck?
No, it is, it's a building dispute, and there's a dispute as to the definition of certain terms.
Yeah, okay, you want to move over here. Now tell me what you have to do to get ready for trial now.
Your Honor, we would just have to maybe depose a few witnesses. I don't know that I'm necessarily an expert. We had somebody that come in and make some repairs. I think you all is more of an expert that in his profession. I don't know that I can find outside person to talk. So essentially, Your Honor,
Well, here's what I've got these, my staff lawyer was called away with a little incident here. I've got these orders that I enter, pretty standard. You have copies of those here? Do we keep about the, in other words, I need for both parties to agree that all the depositions of expert witnesses or anybody else, then they need to give me a list of the witnesses about what, if there's any issues of law that are new or whatever, what your theory is and that sort of stuff. And if you get to the point where the other side is interfering or you being dilatory or that sort of thing, and I can take care of that. But I don't schedule trial dates until people are ready for trial. So if you got any other depositions, I mean, it sounds like you're going to trial. Now, would mediation help in this case, you think? Who mediated? Lambert? To Lambert, did you get close to settlement on it?
I thought we were close, and we've also, I think, come closer since then.
Well, how far away were you?
I believe we're about, what, $3,500 at this point.
What was the total last settlement offer?
So the last settlement offer was that if their clients would agree to cover the amount that was still owing on the summary judgment motion, which was granted to the building supply. So currently my client owes approximately $10,000 to Albany Building Supply for materials. We offered that if they would pay Albany Building Supply attorney said that they would accept $8,500 if paid within 30 days. And we offered to accept that amount if they would satisfy.
And what in your complaint, what's the recovery you're asking for?
I believe in total, it was somewhere in the ballpark of $60,000.
Your Honor, our position starts with that we not reach this agreement. Her client reached this agreement. One worker was not at one right fashion, which caused my client to incur additional costs beyond.
I remember that. I mean, well, let me tell you what. No matter what happens, your client's not going to be satisfied with it, you know, because it's gotten a bad deal. You know, their clients, they're not going to be, because they feel like they gotten a bad deal. So if you're down to just that amount of money with the potential exposure you got both ways, I think y'all ought to think about this pretty carefully. And have you made them a counter?
Yeah, we made the offer.
What's the last count?
Sorry, that was my last offer.
What was your last offer? So the difference now we're between 5,000 and 8,500.
Well, what had happened was we had asked for 22,000 a while back. We didn't receive a response to that. They remained at 5,000 before they were at the mediation, and we offered to come down to 8,500. But my client is not willing to settle because he's been paying for less than what the building supply would accept because he's been paying.
Well, it's just a matter. I don't. 8,500. You need to talk to the client about that. You know.
My client now, that's reviewed it, will continue to think about it. Been in contact with them. I truly feel with the evidence that they have been wrong.
I don't doubt about that, but sometimes you got to stop the bleeding with a tourniquet. You know, it doesn't do that. Well, when y'all get ready to, if you want to spend, I don't know how much it would cost you to get an expert witness, but I'd like to meet him if you got one for less than $8,500. You know, and sometimes things just can't be made right. You just got to push it on. You know, plus the good thing, like with inflation, that 8,500 is not worth as much as it used to be anyway, right?
There's that. Speaking of opposing counsel, she is part of the military, and she's going into an active duty status.
I'm aware of that.
And so.
You gonna volunteer to go with her? They got plenty of room there.
Clearly, I'm not gonna have that look. What, as I understand it, we wouldn't probably be able to have this in her schedule until January 8th.
Well, I don't even know whether it's in, but you'll have somebody that's available, won't you?
Yes.
Yeah. Somebody, I mean, you're talking about 8 months, you know. I can get you trial in 5 months if you get everything ready. I tell you what, if you get everything ready and she's got everybody, she's associated with people that can try this. She can get Mr. Carroll or somebody to come try it. Yeah, so.
I would at least like to say it's a spot for a 5-month period.
You know what? Because I don't set trials, when somebody comes in and they're not ready, I got all kinds of spots ready. I can get you a trial in 4 months, probably, maybe even 3 months, because I don't clutter my docket up when people secure those days and then they tell me they're not ready. Okay, and when you get ready, I can get you a trial day. Don't worry about saving any spot. You know, all you need to worry about around here is, you know, like everywhere else, what's the jury gonna do? You know, I don't know. What a jury. Yeah, it's always a crapshoot. Well, thank y'all very much. So what I'm gonna do is I'm gonna send you all a copy of the order. Make a note for making it an order on it, okay? Have send you a copy of the trial order when you get all those. Hello, Sheriff.
Oh, you're on.
I'm best. Yeah. So send that and we'll do it, okay? Okay, thank y'all very much. Okay, the next one. Is a cabinet in the case here right now? So we'll come back on it. That what? Joshua Renault versus Stephanie A. Renault.
Judge, this one is one that involves myself, Mr. Gibson, and Mr. D from Placer County. This was basically put on for review, but we are in the midst of getting a lot of this case settled, and I think we can just continue generally one of the final motion.
Okay, that'll be good. Aaron versus Guffey. Hey.
Your Honor, this is my motion to set a trial. I filled out the pre-trial brief prior to this. I think Mr. Ramsey's really close.
I've worked on my head.
We would like to get a trial back. We just don't have another option on it.
Give me a thumbnail.
Sorry.
A thumbnail of where you are, how far apart, what the deal is.
Well, Your Honor, as far as settlement, we are as far apart we get. This is a very simple case. Mr. Carter's client alleges that my client stole somewhere in the neighborhood of $40-something thousand in cash from his safe. My client's response is no, she didn't. And so she's not been in a position to make any offers because she doesn't have any money and said she didn't take the money. This would be a very quick trial. I think we could.
Well, it sounds like it's gonna be real quick. He said that she did and she said she didn't. Is that
He said, she said.
We may take longer to pick in the jury than trying the case.
My client said he wants the court to tell him he's wrong. Not getting it right.
We've done depositions.
We've tried to get something done. We just can't get them.
And as far as exhibits go, we've discussed, I think we may have one exhibit or two apiece to introduce into evidence. And besides that,
no DNA or CSI or?
I don't foresee any of that.
What do you want, a jury?
I would like a jury.
I think. She wanted to say.
Oh, you want a jury?
You're welcome.
No, that's all right. I can already see the Solomon bit's not gonna work here, you know, you already tried to split the baby, right? Now, I've scheduled a trial on the 8th of June here. And it was a criminal trial of the Browns. Are you familiar with that? How complex was that? What was that about? What was it?
Your Honor, I'll be out of town on June 9th.
Okay,
My wife says I have to take her on vacation.
yeah. How about July the 7th?
Your Honor, my only issue with that is I have a 3 or 4 day trial scheduled in Wayne Circuit Court that following week, and I'm afraid that my brain will be focused on preparing for that. That's personally.
Well, you told me how simple this case was. Surely it won't be that trying to get
Well, it may
your
not be
client's
trying to
testimony
do
and
that,
said, I didn't take it. Now,
but Your Honor, that trial next week has more money at stake, and I'm going to be focusing my.
oh, okay. Well, you just pick a day then. Hell,
Well, I'm good for any time in August if the court wants to set it. Well, not any time, but I'm much freer in August.
well, pick me a date in August. Some Tuesday, some Wednesday. How about some Wednesday? How about the 10th? How about the 10th of August?
Works for me, Judge.
As far as I know, that works for me.
Okay.
And I can have my trial brief filed within a week.
Okay.
I don't anticipate any pre-trial.
No, I don't anticipate anything like that. Like I said, I think this will be pretty simple.
We'll obviously want to get things set up where the jurors can look deeply in the eyes of both witnesses to discern who's telling the truth.
That's what it's gonna take.
Yeah. Okay. Yeah. Warner Fertilizer versus Lloyd Stockton. Warner Fertilizer versus Lloyd Stockton. Check that and see what this. Harris was involved in it. It's a motion for summary judgment.
This afternoon, they called a notice, but withdraw the motion.
Motion withdrawn. Did I skip over? Where are they at? I don't see it. You what?
You say number 4? Say that. Number 7. It said something about they go on past it, but they're gonna do something.
That they were working on it. That's what they told us. I'll come back to it. Warner Fertilizer versus Brad Urban.
That was also called in this afternoon, council.
That was canceled also. Mason versus Mason. Just say Mason versus Mason out there.
Your Honor, that's just a motion for free, each of the calls, you wanted notice per day, so I think everything.
Make sure that that's okay. We got it. Smith versus Delk. What's going on here?
Your Honor, there's exceptions. I think the court will take this another advice, but I don't know.
Your Honor, Mr. Cross, all the motion to alternate and vacate, you responded, that
Okay, tell me what's going on here.
The wanted for direct, we've had a child either on spring or fall break. We want preschool to begin at the age of 3, and that's for reconsider the 3-4-4-3 split. We filed for documentation with that, it's always filed for response. And
When do you want, let's do one issue at a time, okay? When do you want preschool to start?
4 years old.
Your Honor, what we have filed with courts, was doing some research on this. The experts, whoever they may be, say that whether a child ought to start preschool at 3 or 4 is a decision not best made at a very young age. That's a decision to be made when it's time to make the decision and not before. So we feel like it ought to be
How old is the child now?
16 months, 15 months. I think if you don't know, there's going to be developmental delays, you don't know what's going to happen. There's just a lot of
It wouldn't harm, it won't harm your client for me to take a look at this again. 6 months before school. 6 months before that. That won't hurt anything. I don't think that's unreasonable. That to see how the thing's going to develop. I think that's a very good point. Okay, and what's the next thing?
Your Honor, we believe that Taylor ought to have a child one either the spring break or the fall break when school finally begins. They're big on vacations.
You're losing me on this here.
She's not in school yet.
Yeah.
But when the time comes.
Tell me exactly what you want.
There's a week-long spring and fall break.
Yeah.
We want one or the other.
And what?
Your Honor, we had agreed before this, when we were before this domestic relations with the commissioner to a certain schedule during the school year. My client is only going to have 3 weekends per month. She gets 1 weekend and then a 5th weekend every month, in addition to Sunday night through Friday night. So giving him spring and fall breaks is part of making up that huge disparity in parenting time. He lives in Tennessee, in Holbrook. She lives in Clinton County. They never lived here together. This is just how things have ended up. So
I mean, your client is got the child 90% of the time, doesn't she?
Well, not 90%, but his visitation is increasing as we go.
Yeah. Well,
But this is.
let me, I mean, does it take a whole week to do something? I mean, couldn't you like, I don't
I've
understand.
got a proposal. I think this would be fair.
We want to be fair.
They may want to solve relative, I suppose.
Yeah.
The Delks like to take good family vacations, they go places. I think there's time to plan a week's vacation, but I think that Ms. Hall's client ought to have an extra weekend in there somewhere to compensate that, and that's a fair way to do it.
Well, I mean, if you're talking about a week, that'd be 2 or 3 weekends,
Well.
rather than, you know what I mean? He would take he would take 1 week for 2-3 day weekends, wouldn't he? That way you get one extended vacation, in return you get 2-3 day weekends for.
Your Honor, I think that since we're revisiting the school date closer in time when school starts, this might also be something that we could revisit. And potentially in the next couple of years, these two might be able to work together to figure out.
Well, I won't make an admission. I saw this baby at a ball game. I don't know what kind of child it's gonna be, but it's a good looking baby. I can tell you, I don't know if y'all ever accomplished anything else in your life. Y'all made a wonderful baby. It's a good looking baby. But I'd like for you to think about that. I can understand why somebody wants a spring break or a fall break opportunity to travel somewhere if that's thing. And I also understand that your client has agreed or has gotten less than some people get and why he would want some extra time. So why don't you think about the two weekends? And you would be amenable to thinking about that, wouldn't you? You know, you get 2 weekends and you get a whole week or something like that.
It's pretty important.
Well, everybody's got things that are important to them, you know? Yeah. So I understand. Okay, what's your other issue?
Well, Your Honor, court's order 3443 split. We would just like the court to again review that, reconsider that. We feel like this piece of Sparta, they're here, it's a bit unwieldy.
I do think it's unwieldy and I don't like the law. But I have to have some good reason, you know, to go very much.
Distance is a good reason.
Well, I mean, if they're transported, I don't know. That just goes on to the child start to school, right? Well, that's the reason you don't want the child to start till
Yes, Your Honor.
till 4 and they want to start at 3. That explains something.
We can cut down, or we can alternate weeks. If they want to do a week on, week off, we can do that. as
I don't
well.
really like week on, week off. I even like 4-3, just to tell you the truth. You know,
That's what is happening.
I understand that, you know, and God bless him for like wanting to be around. And most of the time I deal with people that want to run off and leave a child, don't want anything to do with a child. And, you know, I'm glad because it's so important, as I've said before, especially for little girls. And I shouldn't even say that it's important for little boys, but to know that the father didn't desert them, you know, or that doesn't want anything to do with him, or that there's men that love them. And the child got a lot of people that love the child, you know, which need everybody you can love a child. Now, I really don't think I'm going to revisit that 3-4 right now, but I might. It could resolve itself with the child starting to school earlier.
Yeah.
You understand what I'm saying? That could very well resolve itself at some juncture. So, but let's work on that other thing. Is there anything else you got? I will just tell you that and I'll tell you this, Mr. Cross, I really believe with the evidence we had, if this father was denied as much visitation he's got now, that you would not do well on appeal with the way the courts are right now, the way the law is. Because you know, it's just a tough thing with the way it is. And I just think it seems like everybody's getting along pretty well. You know, I mean, as well as you can. Is that right? You're having any trouble with any kind of thing? It could be, and I'm just glad this is the Gerber baby here. When I saw that baby, I thought this looked like a Gerber baby. Ought to be on a jar of candy somewhere, something. But just continue to try to work through things, and if you work through that one vacation thing, I think it'll solve some of the other problems. Yeah.
There was one.
Let her see it first, though, Mr. Cross, you know.
There was one other thing my client asked me to address, and that was, so in the court's order, you followed a graduated schedule, and it actually started back behind where we'd already graduated to, because the parties were abiding by the domestic relations. Or proposed.
I really don't want to revisit anything.
We would just ask that we could stipulate that we're going to continue with the schedule as it's currently ordered until we move to the 3-4 split. He would ask that we move more quickly since he's already had one overnight and every other weekend.
Well, let's just keep it the way it is, okay, and just take some baby steps on this thing. Is the child adjusting pretty well to being with her dad? She doesn't, yeah. Okay, that's a good thing. So we get the vacation thing worked out, then we'll hold off the 3 and 4 thing till we see how developmentally the thing goes. And then it could be by then you feel like that the child is so adjusted and everything's going well that you don't want to disrupt it. You might make that decision yourself later on. And then the third issue then would have been revisiting the split as it is. And that split, I just tell you that the time you're sacrificing right now, I think will more than be made up with how much you're going to have the child when she's in school. You know what I mean? It's a little patience on the thing. And you know, I think Piercy's going to be well taken care of wherever she is. Be a bad thing if she's not, I guarantee you that. So, yeah. Okay. Well, thank y'all very much. Yeah. Yeah. Owens versus Owens. Owens versus Owens. You're gonna have to move over here, Mr. Cross, let him behind the microphone. Speak up a little bit.
Your Honor, this is our motion to show cause. We previously held production discovery and that's not compliant with.
Yeah.
Also got a motion on requesting the court to not forget these proceedings. December, I thought Mr. Cross would have objection to that.
Mr. Cross, what does Mr. Cross owe you as far as discovery? I'm sure nothing.
Financial information which we got, I told Mr. Dale that due to this transition in the office, it would probably be toward the end of the month before I can get it. I think my situation is going to improve the next couple of weeks as far as that goes, but.
Well, we all hope that all of our situations.
I hope we all get better.
I know I could use some improvement, so. Okay, now what do you want to bifurcate exactly?
Just bringing them from the status of married couple.
I can't understand you.
Just bringing them from the status of being married to single. So,
Yeah.
to preserve just.
So you want to get to decree signs, what you want to tell me? Okay, well, if there's no problem with that, we can do it. Just leave it here.
Your Honor, I've got I'm not having these for this court. I've done a small deposition of my client.
Just show it to Mr. Cross and he can leave it up here and be signed today if y'all are in agreement with it. Okay, thank y'all very much. Four Guys Driving LLC versus James Miller.
Justin Noble for the defendant, James Miller, Your Honor. And Judge, this is our motion under 6002 to reverse the summary judgment. Basically, Mr. Miller, who signed an affidavit, never received notice of request for admissions, which was the prerequisite for the summary judgment. Never received notice of the summary judgment motion.
Where is Mr. Miller?
He is on.
Here you go, Mr. Miller. Yeah.
And in the case law says that in the granting of summary judgment motion, strict compliance is required under CR 502.
What are you saying that your client did not receive?
The request for admissions or the motion for summary judgment. And the motion for summary judgment was based on.
Okay, wait a second. Okay, what about the request for admissions, Mr. Cross?
Your Honor, is this Mr. Johnson? I didn't understand.
Can you turn that around? So what can you turn around so Mr. Cross can see him there?
I work with Mr. Johnson. I'm an attorney here with him.
Well, Your Honor, I hope the court has had the opportunity to fully review my response to this motion that they filed.
When did you file it?
Oh, that was filed on the.
I haven't seen it.
Like it was filed.
Did you electronically file it or did you send it to our
Yes,
office?
it was filed on March 25th. And we also filed a supplemental affidavit from the.
Did you electronically file it or?
Yes.
Okay.
Electronically.
Well, I probably didn't catch that.
Your Honor, I'm glad to say that Mr. Miller has misled this court in every respect. based on phone records and messages. And, you know, he got up there the last time and said he hadn't heard a word from anybody and didn't authorize this to be done. Just read my response. I want you to read my response. I don't have to say anything else. He's not in contact with his attorney.
Well, let me tell you something. You got Mr. Miller here today. He's available. Make a short argument. Do the cliff notes of your.
Your Honor, their whole argument is based upon the fact that on the certificate, the zip code is missing a number. Okay, on two certifications, it's 4003 or whatever. There's no proof or no evidence that he didn't get the letter because it's Baghdad, Kentucky. Nothing was ever returned to our office. The only things that were returned to our office, we've got a letter dated July 28, 2021. It's got the 4003. He wouldn't sign for it. He wouldn't sign February 26th, 4003. Their entire argument is that he didn't get notice. But the only thing that they have is not an envelope, not something that's returned, but a certificate that had a wrong number on the zip code. Okay, now that's my fault. Okay, I should have called that when it went out. All that being said, the credibility of all this.
Well, what was the thing? The wrong zip code. Which document was on that? Request for admissions or what?
It was on the request for admissions, and I think the.
Was that request for admissions returned to you?
Nothing's ever returned. See, what it was, and the motion for matters to be deemed admitted, I used the same certificate, and it said 4003. But it's all that. Now, part of what.
Well, let's talk about the mailing thing. Okay. So you had previously mailed Mr. Miller things at that address. Nothing was ever returned to you. Okay, now wait. And so those certified things that were turned down, were they mailed to the same address and same zip code?
Well, it's 40003.
Is it the same address and same zip code? I'm just asking. I'm just asking you a question.
Your Honor, it would be my testimony under oath that the letters that were mailed, every letter was 40003.
I'm just asking if they're the same ones as the certified that were turned down.
You're saying the same ones?
Same zip code.
Yes.
Well, that's a simple thing. Here's my point. If you're mailing other letters there that you assume are being delivered and you don't know they weren't returned, but then you mail certified or registered and to the same address and same zip code, but if they were refused, it would indicate that the letters were getting there. That's what I'm trying to ask you to simplify things. So the letters that you sent with the request for admission had exactly the same address that you sent on the registered letters that he refused.
Yes, Your Honor.
Is that true? And what do you have to say about that, counsel?
That's not quite accurate. The zip code that is on the certificate is the wrong zip code. And all I have to go by in the court file is what's.
Which certificate? The ones he turned down?
The certificate that's on the request for admissions and the motion for summary judgment is
Okay,
inaccurate.
well, let me ask you, what about the ones that he turned down?
Well, those were sent to the right, those would have been sent to the right zip code, but that's not what was on the certificate for the request or the summary judgment motion, and he never got those, so he had no notice of those hearings. And he would testify.
I'm asking you not to argue the case. I'm asking you to look at these letters here. Now, I can't, this letter here, certified mail, that is dated February 22nd, 22, Mr. Cross, I'm looking there. It's James A. Miller, 132 Hyatt Store Road, Baghdad, Kentucky. You with me?
Yes.
Okay, is that one that he turned down? It says refused.
He refused that. He did not accept it.
Okay, now what address did you send the request for admissions to?
Your Honor, the certificate reflects 4003, but we sent them to 40003. The certificate is not the letter itself. We sent it to the correct zip code because it was not returned.
all I have to go by is what's on the certificate and it's wrong. And he says he didn't get it.
May I add something here? That July 28th, 2021 letter that he refused was sent regular and certified. That's what I usually do. You know, when you send something certified. you want proof.
Well, I know, but you sent them to the same address, both of them. And now the ones that you say had the request for admission in it, okay? What address was that sent to? You just sent that regular mail, right? Request for
I believe
admissions.
so, yes.
Well, I want to know.
Yes,
Okay, well, what address did you send the one with the request for admissions on?
the certificate.
Just give me, I don't want to know about.
0003.
Okay, and so we've got one here to the same address that he refused.
Yes, he's refused.
Okay, well, here's the simple point. If you send him a request for admission to 4003, and then you send him something else, another document to 4003, and he refused it at the address, you're entitled to rely upon the fact of the reliability of the U.S. Postal Service. Now, what do you have to say about that, Counselor?
That all I have to go by is the case law says strict compliance. He certified to the court that it was sent to 4003, which the U.S. Postal Service goes by a 5-digit zip code. And if he certified he sent it to a 4-digit zip code, it's not going to get there. It's probably lost in the ether somewhere.
You're talking about his certificate that he filed in support of this motion. Is that what you're talking about?
Of the request for admissions and the motion for summary judgment, both.
You're talking about what Mr. Cross said in the certificate he filed. You're not talking about the documents themselves. You're saying that his error was made when he certified where he sent it. Is that what you're saying?
Yes, and that would be where he actually sent it. That he certified he sent it there.
I don't know if that's where he actually sent it. I mean, he's got these addresses here that said, do you think that you sent it to the wrong address, Mr.
No,
Cross?
Your Honor, I believe that there was a typo on the certificate. I believe that if there had been the wrong zip code on it, if there had been a 4-digit zip code on it, that letter never would have left off there. You know, that's just the way it is, because you can't, it doesn't work. Now, what I want to add is if you can review our response, and you will see that Mr. Miller's credibility regarding what he says is nil. Nil. Make a decision based on that.
Okay, you have anything, Counselor, that you want to add to this?
I would add that the case law says you have to have strict compliance, and it's not strict compliance with the zip code. And we have an affidavit.
Wait, what's not strict compliance?
He certified he sent it to the wrong address. And I can swear him in, and he signed an affidavit that he didn't get it. And that's good. That's not compliance.
Well, I mean, if it was sent to the other address, he might not have gotten, but Mr. Cross is here present saying that he sent it to the correct address, and your client what he has is a misnomer or mistake in his certificate is what he has.
Well, my client will say he will swear under oath, if you want to swear him in, that he didn't get the documents. And if he would have got them, he would have defended the case, and he didn't get notice. And so
Will he tell me why he refused the other letters?
Well, he filed a pro se answer in the case. He was attempting.
I'm asking why he refused the other letters. How did he know that there weren't requests to admissions in the other letter? He was refusing letters that he got, that anything that was certified, he was refusing, correct? Okay, let me swear you in, Mr. Miller. You raise your right hand. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay. Now, Mr. Miller, there were a series of letters sent to you that were certified letters from Mr. Cross and Mr. Wilkinson's office.
Yes, Your Honor.
And you refused to accept them. Why is that?
I don't know what they're talking about. I worked during the day, and if they were trying to serve them during the day, I was not here. So I don't know why the post office would say I refused.
It says refused. It doesn't say that you weren't there. It says you refused them.
Your Honor, I have everything the sheriff's department brought me is certified. I accepted it. I mean, they called me and told me they were coming, and I was there ready for it, and I signed for it and everything. I mean, I would never refuse something if it was certified, if the post office notified me, but they didn't leave me anything. They usually leave a little letter in your mailbox saying that they attempted to serve you and that it's sitting at the mail office. They didn't leave me anything. I don't know where this letter went. I have 3 houses next to me that are all abandoned and they all have mailboxes.
Yeah. Well, I'm going to read Mr. Cross's. You have any questions you'd like to ask him, Mr. Cross?
Your Honor, I do not. The only thing I would add is his affidavit is completely contradicted by our response and our affidavits. And we've got the phone records and the text messages that show repeated contact with Mr. Miller. And he's filed an affidavit with this court. So I didn't hear anything after they said they hired somebody to pull the vote. So he's been very untruthful with this court. Thank you.
Okay. Well, thank you all. And I'll review the responses and issue an order. Okay. Thank you very much.
Thank you, Your Honor.
Next time you're scheduled, I want you all to be here in person though. Okay.
Yes, Your Honor.
Thank you very much. Butler versus Ferguson.
No.
Hello. Hello. What is this?
We don't object, Your Honor. The only thing I would add is when I got this from Mr. Connor, we looked at the file and there was an agreed order he and I executed back in December, and for whatever reason it didn't get entered. I think Mr. Connor would consent to that being entered today. It's in the file.
Hand me the file here.
And after that, give Mr. Ferguson at least 20 days to get a lawyer, but I'd like to get this case back on the next motion there. Good.
Butler, yeah. Matter held in abeyance pending deposition, disposition of a claim in Clinton District Court in the state. Further agree. So you want me to, y'all both want me to enter this agreed order and then who's been entered? Okay. I'm gonna. And Mr. Carr, you got an order, let me withdraw here. Okay. Okay, thank you. Thank you for your patience. Okay. Print that, send that over there. Print. Riddle versus Jarvis. Riddle versus Jarvis.
That's my motion. It's for a judgment order sale on an indivisibility case. No. Did I tender I didn't tender the liability.
No, I understand.
Looks like I need
Or, Your Honor, I think I was waiting based on. Including the, but I'll think her over.
Okay.
That's a big for today, Your Honor. I mean,
Well, you need to sit here and listen to the rest of these people. They've had to listen to you. You sit down over there. Uh, 76 Falls Vista LLC versus Freddie Robinson. I can't hear you. I'm sorry. Just pull the camera. Okay, now this was where there had been a timely answer file, though. That's what I believe there was a timely answer file. Yeah, that's what staff lawyer is gone, but I think that's the problem that we had is complaint was filed. But in this case where there was a timely answer file here, 76 Falls versus Freddie
Yeah,
Robinson.
that was it. Yes.
Yeah, right here on January 14th. He pro se filed a answer. I can get you a copy of that. So it's not fair to hold you to that now, but I'll get you a copy of it, and in review it, you might deem it appropriate to notice him again and say on a summary judgment, he failed to provide a defense or something like that. But there had been an answer, and it appears that he might not have served it. Okay. Okay, will you give Mr. Connor a copy? You want it emailed to you, or you want to wait around for it? Okay. What is that? We definitely want to add more cases to the docket today. Were you friend of the court or guardian ad litem or what? You guys mentioned. We just charge him $500. Do you hear that? This experienced lawyer is just charging $500. Now y'all ought to be ashamed of yourself charging.
It's on the document.
Yeah. Okay. Yeah. Okay, and here is the. And then the one discharged him after that. No problem. Okay, the only thing we have left is confidential. Okay, what do you got going on there? What's going on? What is this? Which case?
on the docket, but I know there were motions filed because I saw them.
Mr. Hurt, tell me what you got. You filed some motions?
Both sides did, Judge. We discussed, I think we have went down to one issue that needs to be heard.
That's well, what is the issue?
The issue that needs to be heard, I think, is actually their motion to enforce regarding the child's participation in a travel basketball game. I'll lay out our position on it. My client's issue is that he only gets to see his daughter 4 days a month. It's every other weekend, Saturdays and Sundays. And this travel team takes up every Saturday.
You don't have to tell me anything about travel teams.
And
If you're involved in travel basketball, whoever sets that schedule thinks that you don't have any other life at all. Now, I think both sides.
Well, that's the way it feels to him.
Well, I understand that. Okay, what was your resolution to that? I mean, you don't want the child not to play travel.
This was discussed between the parties.
What's your resolution?
He proposed the child playing a local Clinton County team that would allow the child to have a good sports experience and do those. And not take away literally 100% of the trial, because these it's football, it's other places, so it eliminates all time essentially with his family and the child. He proposed the child playing a local sports team, so that the child
And not play
plays-
travel ball?
Well, not play travel ball in a team that essentially eliminates 100% of his time.
Well, I mean, is the Clinton County team going to be travel ball team?
No, it's I guess.
So the thing is that he thinks that child shouldn't play travel ball, but should play in a local league here in Clinton County.
That would, in his view, be fair. And that
Well, just
the
tell
child-
me yes or no. I don't want you to
Yes,
argue it.
that's
I
what he-
just want to know what his position is.
That's-
Yeah, come over here near the microphone here.
Judge, first of all, we would say the travel team has approximately 4 to 5 weeks left, and this is something that this child wanted to play. She's very good at this sport and was offered to play on this team, so.
I got, what is, you understand what the problem was? Are you willing to give another day?
We have, and we proposed that to coaching council, that when if she's there on Saturday and Sunday, we will let her make up this visitation during the week. We proposed that until the travel team is out of session.
What, does it take a Saturday and a Sunday?
It just depends. Sometimes it is both days, sometimes it's only Saturday, sometimes it's only Sunday.
Well, I would suggest that, and that's every weekend though. He gets a child every other weekend.
Every other week.
See, there's not a weekend for him to make it up if it's every weekend.
That's correct. And my client says, of course, she's not getting weekends with the child either. I don't think the week is necessarily fun for them when you have school.
Well, she's getting every other weekend with a child, isn't she?
Correct, she is. And there's 4 to 5 weeks left before this is over. We don't
Well,
know
I
what's
know,
there.
but this will be a recurring issue. I mean, you don't get a child, in my opinion, from what I've seen, you don't put one on a traveling team and then quit.
Well,
I mean, because how old is she?
She's 9. Yeah.
10. Well, I mean, she'll get more connected to these other kids on the traveling team and she'll want to do that. You'll have so I think there should be somewhere, if you're going to do every weekend traveling ball. I don't know about that anyway. You know, it's so unfair to these kids. It seems like to me, if they aren't in traveling ball, that they get left out sometimes, even in their own local school things. You know what I mean? If they haven't been traveling. But Clinton County has pretty competitive intramural sort of things going on.
Judge, we don't say, we're not disagreeing or agreeing that she could never be in the trial. And we're just asking that she be allowed to finish up the rest of the season and for her not to be made to quit during the middle of the season and let her finish until May. And then when it's over at that time, myself and.
What kind of visitation does the father have during the summer?
Every other weekend as well, Judge.
Well, and does he have a week or anything?
He does not. Well, I'm not gonna, he may in that previous agreement,
What do you usually have in the summer with the child?
Supposed to have every other week.
But do you have any vacation week or anything with the child?
We are, according to the old decree, it's been brought to my attention that there's a new one in place I wasn't aware of. And so I'm not sure exactly how.
What do you think he's entitled to during the summer as far as a vacation week or something? I'm not asking what you'd love to do. I mean, no, everybody wants to argue a case for me. I just want to ask you what he's entitled to right now as far as If she becomes older, are you married now to somebody else? Okay, and you have other children? Well, so at some juncture, it'll be like the case we had a few minutes ago. This child will be old enough that he'll want to take her and his younger children on a vacation sometime. And if that's not in the agreement now, we might be able to use that to satisfy these extra weekends. You see what I'm saying?
Judge, each party is entitled to a 2-week vacation with the children in the summer.
Okay. Okay.
That party has to give the other party 30 days notice of the requested vacation date and itinerary.
Well, let's say, and are the 2 weeks, they have to be all continuous, the 2 weeks? Is that what it says, or it just says
It
2
doesn't
weeks?
specify, it just says 2 weeks. This is a order that was adopted by the board out of Washington.
How many weeks do they have off during the summer? How many weeks?
Yeah, it's, they go to mid-May and they usually start the first
Second week of August, yes.
Yeah, that's not right. No wonder the country's going to heck. These kids don't have enough long summer vacation. So they have 8 weeks. He's entitled to 2 right now. How about let's do him 3 and 5, let him pick up another week. And then we won't end the travel ball this year. Let him do the travel ball and you pick up another week in the summer. You have a whole week. You got 2 whole weeks now for vacation. Now you're gonna have 3 whole weeks in the summer. You follow what I'm saying? And that about equates 3 weekends.
Okay, and, does that mean that it has to be an active vacation, or can I say, hey, I'm
No,
taking vacation?
no. Staycation is fine. More as gasoline prices go up, we'll have more people doing that. So, I mean, if you wanted to do a staycation or whatever, and then you do 3 and 4, and that'll make up for these weekends. And then a joint decision will have to be made next year about whether you're gonna do the travel ball, because let me tell you what, it'll consume both of you. I know they want to play this travel ball. I know it's important. And if it turns out to be an athlete that it will be advantageous to, they just about have to do that in a way, but it can ruin your life. Travel ball game. And you're gonna find out about that pretty soon too. Yeah.
I did have one question.
Yes, sir.
With that being said, so the old schedule every other week through the summer.
Still goes.
Okay.
Y'all can make that every other week, except when you get, it still goes except the week you got the child, and the week you got the child will be your weekend. See what I mean? So that week, instead of 2 days, or you get you get 7 days. You don't get that and that weekend too. You understand what I'm saying? So you'll have 3 full weeks during the summer, but they would probably be on the weekends that you would have had the child anyway. So you actually add, additional 5 days or something like that. And that's about what you lose on these weekends. Is that acceptable to both of you? And I think y'all talk pretty well now, or no, you can't talk. Okay. Well, somebody needs to think about this travel ball and what
We
it
discussed
does.
it prior to it happening, and in the text, she also agreed that we wouldn't do it. And then later, after she told me to tell Gracie no, and I did, she signed her up anyway.
Well.
And I've got my daughter telling me she doesn't want me to be her daddy.
Yeah, well, okay, I understand. Well, let's be a little careful about the travel ball before we make any commitments to it. Again, okay, and but if y'all can't agree on not doing it, or if you can't agree on doing it, and I do think that we want to emphasize this status quo thing where no parent says anything. And I keep on coming back to this program, this app that people got about communication. You know how to get that one? It's what? It's an app that.
We use it on another case. I can't remember what it's called.
Yeah, but there are 2 apps, and here's what you do, is when you got people that have a hard time communicating anything, this is the only avenue of communication. So everything's written down on that app. When you communicate with each other, everything's there, the dates, the times, and it's just a good idea for the protection of everybody involved when you got people, and that way you never have to talk to each other again, and just think about that. If y'all, the 2 of y'all will look at that, okay?
Judge, one thing we would request is when the child does have games or practices and it's in there with the opposing party, and then if they're not, if he does not have the means to take the child there, that my client will be allowed to take that child to practice or games, because they're just not attending the events that they have on the weekend jobs that are with him. So if he has them there practicing.
Well,
or games,
we're just talking about this travel ball right now, right?
that's correct. Just-
Well, let's go ahead and work through the travel ball. Let her pay the travel ball this year, and you get those extra days back that you aren't doing. And then I don't know whether the travel ball is ever gonna work. It's just gonna be too much unless the relationship, unless there's a Damascus sort of experience. Everybody's, changes their feelings, and I don't think that's gonna happen for a while. Okay? Thank y'all very much. Yeah. What else? We have the confidential matter. That's all we have now. We off the record? Let's go off the record. Go off this thing too on YouTube.